56(9) without telling the counsel is seeking the court slip for tomorrow, then this case does not pertain to our roster. This is a matter to be heard by DB3. Then don't do it, madam. As an officer of the court, we rely on you. It is your duty. Otherwise, and what will happen if the matter is listed, you won't come. Your senior will come. Huh? No, we will haul you up for this thing, right? Making wrong statements. Be sure. We are relying on you, but in case it is found to be incorrect and the case is now for not found to be of our this thing, and in case you are seeking hearing, we are telling you it won't be listed, right? Despite mentioning. So it will come only on IA for expedite hearing something. Yes.
Lord, UG admissions, my lord, today listed.
Arey, you didn't go to Supreme Court.
Lord.
Huh?
My lord. Similar.
Yesterday got the copy, no?
Lord, after yesterday, I'll never go to the Supreme Court.
No. Arey, this is Mr. Lighter. See, Mr. This is, you have a constitutional right. Right to access to justice is basic feature of the Constitution of India. Which judge, a legally trained mind can say this? But see, what sort of a beginning we had today. The council did not know which provision he has challenged. So we are just trying to make the atmosphere informal. And we hope that you take the humor in its appropriate this thing and not feel that there's nothing, right? You have a right to go. You have any order, you can approach. That is your constitutional right. We can't deprive. This is just trying to be humorous, nothing else. Don't take it like that you will never go. Why will you not go? You should go.
These are similar candidates, my lord, seeking impleadment in the pending matter, my lord. UG admissions, your lordship passed an order. Similar candidates, my lord, there. My lord.
An order and
no, then this UG admissions, my lord, your lordship passed order on Saturday. UG admissions to be considered.
Which petition? So next week it will come up.
Well, today they are listed. Some of them are listed. Even my matter is listed. In that matter, they're seeking impleadment.
Today matter, which item? Then you 84. Should 84. You want impleadment.
Yes.
All that application.
Yes.
Please, commercial court written petition which was listed on 17th. Service of papers to
commercial court matters. 30th August.
Proceedings are coming on 1st of September. That's the reason
why do you want listing?
Stay up and stay. Keep proceedings.
All right. 31st August. 31st August. No. So how Mr. Prabhakar will deal with this? He doesn't know. Have you served him a copy? No. So what were you doing then? Your case was not listed for final hearing, other cases listed. What were you sleeping? What did you do?
Item number 109. Teachers, not medical.
Not medical batch, Mr. Don't say. No. File an application for linking of the petition along with that. It's not that this thing. Teachers batches. That's right. You make an application for linking, it will come up. Yes.
2018 writ petition 2018 writ petition pertaining to Reorganization Act. We have moved.
No, you want final hearing, madam?
IA, my lord, we have filed.
Which IA?
IA 1 of 2023. Expedite petition to
on expedite petition on 5th September.
My lord, this matter regarding appropriate all the matters.
Huh? No, what have you challenged, madam?
GO 75.
I don't get it, GO. I don't get it, right? You people have read it, GO 75. What does it provide?
All the connected matters.
That is what your senior said. Tell the court that all connected matters are listed. So ask for a lunch motion. That's all.
What GO? What rule have you challenged, madam? This is the question. One council went away because he did not know what provision he has challenged. You also don't know. So first read, go and read and then come.
File it, it
Read
will
it.
come tomorrow, madam. Don't worry. Yes.
Yes.
Item 1, visit to forest.
Lordship's permission, Lord, I prepared the
Huh?
brief short, Lord, for the conveyance of my Lord.
You say what brief? This is admission, right?
Lord, admission.
Admission. No, you tell us. Once there was already an order of compounding on 27/3/2020,
Yes, sir.
and he complied with that order of compounding.
Yes, sir.
Once again, you can pass an order of compounding. That's what I was.
Lord, the case is
I
like,
know.
Lord,
Please
the case is
explain.
like this, Lord, once the Lord, for the grant of the.
No,
Lord,
cases like this, what we will
No,
tell you. Just a minute. What is the case we will tell you?
Lord.
Then you argue.
Lord,
Petitioner was granted a license for setting up of the forest produce
my
depot.
lords, my lords.
27/4/2019 during inspection. Wait, during inspection. It can't be better than court telling the facts, right? Can't be better than for you.
Lord,
So therefore, it's not that we don't want to hear. You are arguing on admission only, right?
Yes.
So we are asking you. So petitioner was granted a license for setting up of a forest produce depot.
Lord,
27/4/19 during inspection, flying squad
Lord,
headed by respond number 4 found that 7 kilns were burning and 21 kilns were have been manufactured, right? Then you passed an order of compounding on 11/11/2020.
Yes.
Passed an order of compounding on 27/3/2020. That order of compounding was complied by the petitioner. Thereafter, you have again passed an order of compounding on 11/11/2020. The learned single judge has set aside the order of compounding on the ground that previously an order of compounding was already passed, which the petitioner has been complied. So there can be, according to this thing, there can be two scenarios. This must be compounding in relation to some other forest offense which or something other him have committed. And this is 11/11/20 is different. It can't be in respect of the same subject matter. Perhaps this is what you want to argue.
no,
No, all right.
altogether different.
You,
Altogether different, Lord. I just, Lord, the sum of the, Lord, brief.
no. So facts are correct, right?
My lords is right, Lord.
We have to be right.
The impute
Mr.
order, Lord, my lords is right.
We have to be right. And second thing, we don't dependent on you. We are not dependent on your certificate of saying that we are right.
I am on that.
Yes. Number
My
one.
apology.
Submission.
My apology, Lord. Lord, the case is like this, Lord, on 27, Lord,
No, this is only for admission. Tell one point.
24/7/2019, Lord, the license was granted to convert the one product name, Prosofia.
20,
Lord, the 24/7, Lord, the 24/7/2000, my apology, Lord.
24/7.
16/7/2019, relevant date, license was granted to the Lord the respondent. Lord, convert the one forest one Lord, the tree, so pieces, two into the charcoal. That license was granted for the 45 kilns. Lord, the rule says the concerned DFO have to visit and see that if all the kilns were settled, Lord, after verification of the concerned superficies only, he has to accord the permission for the converting into the charcoal. My humble submission, the concerned officer, Lord, himself, Lord, committed to the gross irregularities without 45 kilns, which is the mandatory under the rule. He granted this license. When the officer my lord, the concerned officer visited the site, flying squad, on 24/7/2019. 24/7/2019.
Have you taken any action against the officer?
Yes.
Just now you said, has he been
Lord,
placed under suspension?
Disciplinary action was taken.
Taken.
All are suspended. One concerned DFO is not getting his pension also.
All.
I made it very clear. Lord, within the 1 week, Lord, it is the duty of the statutory duty of the officer to visit the site and confirm whether the other species were used in the conversion of the wood to the charcoal. And he
You have
found
to
one.
tell Mr. a point for admission, right?
Yes.
Immediately.
My-
We are again
now-
saying that you are arguing on
Yes.
admission,
Yes.
not final hearing.
Lord, instead of 45, Lord, the officer vigilance visited and found only 28. Even 28 also 7 was already burned and 21 was ready to burn. Lord, this is gross irregularity. Immediately, Lord, the concerned DFO. Lord,
So revised compounding order was passed without notice to petitioner.
Lord, the petitioner was given thrice notice, that is the impugned order clearly demonstrates. Thrice. The dates also mentioned. She says that I am the pregnant, I can't go. Lord, my humble submission. Lord, for the sake of my Lord's only admission point, Lord, the vigilance officer visited and found the illegal production of the quantity of the timber to the tune of the 39,61,402. That is my short notes demonstrates. Lord, immediately in
It
conclusion,
is not short note, it is 5 pages.
Lord,
So you have to tell us which page.
Lord, page number 1. Lord.
Short note. Where is the figure?
That's point number 4. Lord.
No, so that you must tell.
When the factum of fraud clearly manifested on record, 39,61,402 lakhs was initial valuation done by the vigilance officer. My lord. Immediately, the concerned DFO who is involved with the malified intent constituted one committee with the 3 range officers. One officer confirming the 39 lakhs rupees and the 2 officers reduced it from the 4 lakhs. My lord. Even otherwise also, the DFO within the short period compounded the offence by collecting the 10 lakhs rupees. The fraud, my lord, initially the statutory provision says that after the complete setup of the kilns only, he has to visit and grant the permission. There is that irregularity. Second irregularity, he reduced the 39 lakhs rupees to the 4 lakhs.
So he means who? He means who?
You know, the concerned DF, first officer who granted the sanction.
What's the name? He has been having a name.
K. Krishna, I have
So
taken.
he has been placed under suspension.
He was placed in the list of dates, not 14/5/2020. No.
And D pending.
The charge memo was issued. His pension was stopped. The other
So what happened to charge memo? 3 years. There are instructions, no, D should be concluded within 6 months.
There are the total 2 DFOs were held responsible for this irregularity, and 2 range officers were made allegations, and they are facing the
No, this all, you are still not told what is the point. Despite
is
that,
my-
we have heard you for 5 minutes uninterruptedly. You are not prepared to tell what is the point for which the appeal should be admitted.
I beg to differ with the findings of my lord's learned single judge on its own 2 occasions.
No, you are not a judge, you can't differ. You cannot differ. Nobody is asking for your opinion. No, nobody is asking for your opinion whether you agree or not agree. It's an order passed by this court.
Yes.
Learned single judge of this court.
Yes, my lord.
You are in an intra-court appeal and not telling why the order should be set aside, or if
Lord, the-
appeal requires admission, you are not telling. So far.
Not played by the officers who are facing the disciplinary proceedings. Lord, it is a loss to the exchequer to the tune of the more than 90 lakhs. Lord, the case is made out. Lord, even otherwise impugned order, there is a provision of the appeal. It was not, Lord, they are availed. Stayed away. They
No,
are
see,
my
the
lord.
problem is you are obsessed with the fraud. You have to make out a point. You officers have committed fraud, therefore they are suspended and you are proceeding. terminate their services.
Applicant should not go, not the spot free because of the, some, the point is that if the subordinates.
Arey, Mr.
Commits in,
You don't understand, Mister. Despite being told you don't understand and you are not agreeing with the order of the learned single judge. Firstly, you don't have any business to agree or disagree. Secondly, that your submission only shows that you have not read the order passed by learned single judge. Single judge has quashed your order on the ground that initially an order of compounding was passed on 27/3/2020, which was acted upon by the petitioner by depositing the amount. Therefore, you could not have again passed an order of compounding.
What is the undervalue, my lord, more than 35 lakhs
He doesn't have,
primary.
he does not have the power to cancel the earlier.
And which is the power to cancel the order of compounding? That's what, brother.
Section 66, my lord, of the Forest Act.
That you are not arguing everything fraud, this thing.
Lord.
No, it's not that this thing, Mister. We
My
come
apologies.
across very such submission, like very attractive thing, and fraud is one of the most difficult things to prove. See what are the requirements of pleading a fraud? What is this? Just like casually fraud, some. Make out a legal ground fraud admission in 2 sentences. You have done a good job by preparing this in our short notes, but they are not short notes. We will term them as long notes. 5 pages. Very good. Keep it up. Now get into the art of précis writing. Date. Awarded license to do so. Flying squad. You begin by fraud vitiates everything. Because mind is obsessed with fraud. Fraud is not the issue in the writ petition. He has filed the writ petition challenging the order dated 11/11/20. So first point is not fraud. First point is your authority to reopen and to this thing, right?
Exactly.
Issue a revised penalty or revised this thing, compounding order. That is the issue. Then comes last submission should be that he has committed fraud. We have suspended him. DE is pending. Then we will direct you to submit status report with regard to DE. Because the moment this petition is allowed, you will revoke suspension and pay dues to him. This is just for the, we must have told him it's only on paper. We have to file a writ petition in the appeal in the High Court. So don't worry.
They are not getting pension also, some officers.
So what have you done? Filed an affidavit. You said that 14/5/2020 disciplinary proceedings were initiated. 3 years. What have you done?
Not the,
What is the circular of your department to show within how much time disciplinary proceeding should be? Don't go on a track which is not necessary. First of all, this is not relevant for the case, right? Secondly, firstly, you are here to defend the order 17/11/11/2022. Do it. Yes.
not
Provision is mentioned. Which provision?
section 66, my lord. Telangana Forest Act 1967.
Revision.
Reason.
Hmm.
I permitted to read, my lord.
60.
The government may.
The government may sue moto or on application made to them call for and examine the record of any forest officer in respect of any proceeding, not being a proceedings in respect of which a suit, an appeal or application or a reference to a court is provided under this act, to satisfy themselves as to the regularity of such proceedings or the correctness, legality or propriety of any decision passed or order made therein.
They can do.
And if in any case it appears to the government that any such decision or a order should be modified, annulled, reversed or remitted for reconsideration.
So what is the legal submission, Mister? Fraud, etc. is all right. What is the submission? Still waiting. 10 minutes over.
My lords, because of the wrong assessment, irregular assessment, my lord, the use of the everything. The initial, my lord, the initial wrong committed by the officer itself is the foundation, my lord, the reason, my lord.
Which provision order of compounding? Which provision? Telangana Forest Act order of compounding. Doesn't know.
Page number
59.
Section 59. how much compensation was,
10,000.
10?
10,000. 10 lakhs is the penalty.
no. 27/3/2020, who imposed the, who levied this thing, accepted the compensation? Compounding compensation, what was the amount? 27/3/2020 earlier. What is the ground of reopening?
Lord, the ground is Lord, the
First, 27/3/20, how much amount was levied?
10 lakhs. 10 lakhs and a 10,000 penalty.
So why you have reopened?
Lord, this was reopened basing on the report, Lord, conducted by the committee constituting the 3 members who gave that Lord, the one of
No, who constituted committee?
committee principal secretary, principal PCCF, Lord, principal chief conservator of the forest, who is the head of the department. On his instructions, Lord, vigilance department visited the site and made the fresh inquiry, and assessment was done, which is the two matching
Committee, who were their officers of forest department?
district forest office.
So then what they submitted a report?
They submitted a report that because
Fraud.
of fraudulent irregularities, Lord, the officers
Irregular.
undervalued the quantum which is found on the site, Lord. And
Then
photographs
did
also,
you issue notice to him?
we have issued them, Lord, the notice at 3 occasions, Lord, in the,
No. Have you heard him? Have you heard?
no, he is not turned, Lord. He is not turned, and on 3 reasons he is not turned, Lord, on the 3
When
occasions.
notice dated, when it was issued,
Lord,
notice dated,
Lord, the 25/8/2020,
notice dated 25/8/20.
yes, Lord.
So where is this this thing gone for short notes gone? It's not there here anywhere.
Lord, the dates.
Short note is about fraud, right? Not relevant facts.
Page number 52, Lord.
List of dates also.
Page number 52, Lord, 3 times.
No, where list of dates and events?
The list of dates which
It was missing, Lord.
Missing.
That the dates are not there. Lord, impugn notice, page number 52, Lord, the 3 occasions notices were
Date, mister.
issued. Lord, 25/8/2020. Lord, the 10th September 2020,
Huh?
10th September 2020,
Huh. No,
30.
25/8 is which page?
Lord, page number 52, Lord.
10/9, which page?
Lord, 10/9 also same page.
Same page.
Same page, Lord, the 3 occasions, Lord. An opportunity of has been provided
25/8, 10/9, and so 3 notices were
39.
issued.
39/2020,
13/9.
2020. And 9
13/9/22.
2020.
So you send notices on 25/8, 10/9 and 13/9. 13/9/30. Where is that notice?
Notices are not filed.
Why?
I
And by what mode it was served on him?
will please.
Yes. And change this thing cost title by instead long notes, not containing notices, you give the heading. Prepare it another way, mister. We want you to improve. That's why. Give it back to him. This you give it back to him. This prepare it properly. List of dates, everything should come. This intra-court appeal heard on the question of admission. This intra-court appeal has been filed against an order dated 28/3/2023 passed by learned single judge, by which writ petition preferred by the respondent has been allowed. Paragraph. The petitioner was granted a license. Petitioner was granted a license on
16/7/2019.
16/7/2019 for conversion of Prosophis PROSOPHIS into charcoal of 45 kilns, full stop. The flying squad on 24/7/2019 during inspection found that the flying squad headed by respondent number 4. Respondent number 4 is what? Respondent number 4 is Forest Range Officer. Forest Range Officer Karimnagar during during inspection found that 7 kilns were burning, whereas 28 kilns were manufactured. Full stop. Thereupon, paragraph. Thereupon, a notice was issued to the petitioner and a notice was issued to the respondent and in exercise of powers under section. Which section?
59. 59.
Revision.
Under section 59. Under section 59 of the Telangana Forest Act 1957 and the 57 comma order of compounding dated 27/3/2020 was passed, by which a penalty of rupees 10 lakh record needing to produce the record to demonstrate that before passing the revised order of compounding dated 11/11/20, the respondent was given an opportunity of being heard. And what manner you have served the notices, find out. And so all this must contain, right? I give it back to you, but you must give it back to us on next date. Huh?
Yes.
Very good.
Yes.
Very good, mister. This is what you should do. But you should understand what is relevant.
Obliged.
Item 2, Surendra Desai, repeat the revenue.
Right, this last delay in resubmission, my lord, on 48 days delay is resubmitting the file.
Condoned. Delay in resubmissions condoned. All right. IA is allowed. Yes. What do you say?
My lord, we have served papers on
My lord, I'm for the respondent counsel, my lord. So, we're taking the copies today. We'll serve the counter in 3 weeks.
Nobody has asked you to serve counter, file counter.
I'm for the respondent counsel.
Respondent counsel. So this is a writ appeal.
Yes, my lord.
Which provision under the rules you are entitled to file a counter in a writ petition, writ appeal? Please enlighten us. We don't know.
Lord, I'm not briefed about the case, my lord. I was only
Then
assigned.
don't appear. You have been briefed to this thing, impede the course of administration of justice by seeking adjournment, right? Sit down. Sit down. Sit. Please sit. If you don't know anything about the case, you should not appear. And tell your senior that the court asks that under which provision in writ appeal counter is filed.
Yes.
Ask your senior and go and in the library, study it, find answer this to this query in the evening, then only go home, right? Otherwise, don't go home. We will permit the library to be open for you. We will tell them that this thing, and young advocate is searching something very important, so you should allow him to continue. Go there in the library. Yes, Mr.
Yes, my lord.
So order has been passed in violation of natural justice.
Yes.
Then
This writ appeal is filed, my lord, against the order of the learned single judge, my lord. In the improved order, learned single judge takes two things passing order. One is, my counter, I stated that it is a,
not getting.
Go to para 7.
yes,
The learned single judge recorded a finding that notice was not given to the parties. Please go to para 7 at page 25 and read the 6 lines.
yes,
The fourth respondent herein, without putting all the interested parties on notice, proceeded to issue the impugned proceeding. Even the notice issued in form 8 as required under subsection
So
2.
that-
So, also shows that the very same is served only on the applicant,
the respondent.
but not on the interested parties.
Yeah, but the issue
You
is,
will be heard.
no, one submission, my lord, here is, the writ petitioners and others, mainly they are representing the 4 branches of their respective forefathers and grandfathers. The mutation concerned is only regarding the branch 2. Branch 1 and branch 3 and branch 4 have got
It's a-
separate mutation.
As you argue before the authority, branch 2, 4, this writ petition, the learned single judge has not decided title of any of the parties, nor we can do so. 5, 2 constitution bench judgments of Supreme Court, not only Supreme Court, 2 constitution bench judgment of Supreme Court prohibit us from entering into question of title. This is only a question of entry in the revenue record, which does not confer any title. Even in that matter, you have been given an opportunity, raise all possible objections before the officer. We will not permit you to argue your title here and give a decree of declaration that you are the owner and these petitioners should be put behind the bars. This order we will not pass.
My respectful submission, my lord, one respectful submission I will make, my lord. It's question of notice, my respect, the submission doesn't arise, my lord, first of all. It is not,
You don't want to be heard, right? So because you say question of notice does not arise, we will say that he will decide it without hearing you. Because you are saying that it is not necessary to notice.
no, my lord, the question of issuing notice to other especially writ petitioners does not arise because what is mutated is from, I have by way of succession from my own father and grandfather, not from the other branches of my great grandfather. They have got their own mutations, which I was not issued notice.
Mr. Counsel,
Yes, Minad.
by putting the other party on notice, what damage it is going to cause you? It will only allow every party to put up their case. What is the basis for their claim? That is what the learned single judge said in para 9. And when the matter is remanded, that first of all, you should understand under clause 15 of latest patent. it
The
will-
appeal would not lie. It's not order, it is not an order adjudicating any rights.
Only one is going to,
Only we should dismiss you.
only one.
Test it before Supreme Court. Test it.
I won't say that. Only one submission. In that event,
This is order of remand.
one respectful submission, Minad. In that event, all the mutation proceedings issued in favor of the writ petitioner to their lands, that also should be remanded for the entire hearing. The matter does not particular to only 1/4 of the entire extent of 90 acres of land. Those proceedings.
File a petition. We are not pass any order in respect of which other land which is not the subject matter of this appeal. If you feel it should be remanded, file a petition.
That aspect was not been considered by the learned single judge, Minad. The mutation proceedings, if no notice is issued,
Fine. This intra-court appeal has been filed against an order dated 16 December 2020-22 after delay condoned, right? Heard on the question of admission, this intra-court appeal has been filed against an order dated 26 December 2022 passed by learned single judge, by which writ petition preferred by the respondents number he is not described here in the writ. R4 to R6. By which writ petition preferred by respondents 4 to 19 has been allowed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that respondents 4 to 20 in the writ petition, 4 to 20 in the writ petition submitted an application 4 to 20 in the writ petition, comma, submitted five separate applications before Tehsildar, district collector, before the district collector.
at that time, Tahsildar was the competent authority, Minad. After amendment, district collector has become the authority.
Before the then Tehsildar, without disclosing the existence, without disclosing the right and interest of the petitioners in the writ petition, seeking succession and mutation of their name in the revenue records. Full stop. The notice of the proceeding issued in Form 8 under Section 5 within bracket 3 of the Telangana Rights of Lands and Pattadar Passbook Act 1971, hereinafter referred to the Act, was served only on respondents 4 to 20, but the same was not served on interested persons and was also not published as required under Rule 19 of Telangana Rights in Land and Pattadar Passbook Rules 1989. Full stop. What collector granted an order of succession? The Tehsildar, Ranga Reddy, Tehsildar, so and so, Maheshwaram Mandal, Ranga Reddy district, granted an order of succession in favor of respondents 4 to 6, 7 to 9, 10 to 15 and 15 to 18 and 19, 15 to 20 in writ petition, granted succession by orders dated 19/6/2020, granted succession in favor of, you write like this, collector, district collector, so and so, by an order dated 19/6/20 granted succession in favor of respondents 4 to 6, 7 to 9, 10 to 14 and 15 to 20 in respect of land bearing survey number 122, 135, 136, 137 and 141 of Mankhal village, Maheshwaram Mandal, Rangareddy district. Paragraph. The petitioners challenge the aforesaid order in a writ petition. Learned single judge inter alia held that the notice was neither served on the petitioners nor on any of the interested parties as required under Rule 19. As required, full stop. It was further held that the notice was not published as required under Rule 19 of the Telangana Rights in Land and Pattedar Passbook Rules 1989. Full stop. The learned single judge therefore disposed of the writ petition in following terms. Quote para 9. Right. We have heard learned counsel for the appellants at length. Full stop. Since the order dated 19/6/1920 was passed by the Tehsildar Rangareddy district without serving the notice on interested parties, and the notice was also not published in as required under Rule 19 of the 1989 rules. Therefore, the learned single judge has rightly remitted the matter. Needless to state that it is open for the appellants to raise all such contentions as is permissible in law for him to contend. We do not find any merit in this writ appeal. The same fails and is hereby dismissed. Yes,
May I request for personal hearing before the collector, my lord?
you request.
Last may I observe that, my lord.
May I please your lordships. The writ petition filed, my lord, challenging the order of my lord's Green Tribunal Chennai. This order has already been challenged. my lord.
Appeal.
Order has already been challenged before this honorable court. My lord, page 181 is the order copy, my lord, sir.
180
Yes, my lords.
already challenged.
Yes, my lord.
Dispose of similar such matters, all the pollution NGT order, the local pollution authorities gave some proceeding asking them to deposit.
We have disposed of some matters directing them to go under 31 capital B and 33 capital B.
No. So you have already challenged, then why have you filed another petition?
But some others.
You have a right to this thing, right? Pollute and not to pay anything.
No, I've been given.
And contend that this is all time barred and this. The only ground is time barred. What is your defense? That you are not polluting?
I've taken, my lord, I've taken permission from the Pollution Control Board, my lords.
No, permission means so that permission is liable to be revoked because you people are medical waste you are dumping in water bodies, right?
No, my lord, we are not dumping, my lords. We are not dumping, my lords. We are treating, my lord, as per the permission, not we are treating it, my lords. We are no dumping, my lords.
But appearing for the respondent number 4 in this matter, my lord, what
Why don't you examine their facility, Mr., and give a report? What is this? They are dumping biomedical waste in water bodies and everywhere, like, and that's why there is a fine. And this all technical grounds that it is this thing barred and only 3 years. So supposing if you have committed a person, murdered a person 14 years ago, you will say barred by law. I cannot be, no criminal case can be instituted against me today. It's like committing an offense, Mr. Please appreciate the gravity. This is not for this thing, it is for future generations.
The bodies are drinking
I understand. my lord.
Huh?
drinking water.
Water bodies and drinking water source, you are releasing the biomedical waste.
My lord, we are the downstream, my lords, of the drinking water lakes, my lord, not on the upstream. We are downstream.
25 lakhs only you have been given. Fine.
On Pollution Control Board it was.
No, pay the fund to green fund. Green fund created by the government.
That was-
Contribute. You under corporate social responsibility, CSR initiative, right?
That fine was on.
How much are you paying under this thing? Green fund, corporate social responsibility, what is?
That are to ascertain, my lord.
Ascertain.
Mike is not up, mic on.
The 25 lakh.
No,
penalty.
Mr. One thing, he has not concluded, I mean, he has not argued anything except showing interim order. So if this order has already been stayed 23/3/23, so why have you come again? There is already state, right?
Because, my lord, part-
You are which medical college? You are some other medical college.
Item respondent number 9, my lords, in the OA at page 155.
Is there a correction in medical college at the stage of in Boston? Upbringing applications. Those that are in the No.1 GO villages agree to them. See.
So like one after the other, huh? In this order also, there is a reference to earlier order.
Yes, my lord.
So you tell us that you have challenged this order after 4 months. 4 months. What were you doing and why we should not deny the interim leave? Those people were very prompt and came early.
The signing authority, my lords, was, the signing authority was not available, my lords, it had to stay for some time, my lords.
This order was passed on 25/4/23. Why similar order after 3 months should be granted in your favor? Explain what were you doing?
That,
What is the stage of recovery?
my lord, the mine was on pollution control board, my lords, they approached.
Let them respond. Huh?
Praveen, I don't think it is your college is downstream.
Yes, my
Where
lord.
don't make incorrect statements,
Yes,
right? We are
downstream. It is-
capable of,
It is
Keep it-
Aziz Nagar, it is not a downstream. It's an
we
upstream.
will,
Aziz Nagar.
we will appoint a commission of this court and they will, this thing, find out what are you doing.
We are not.
No,
discharging
no,
anything,
Mister, this is crime, right? Who knows that that very water may be supplied to you? You and your children. It's so, this don't, I mean, it's not a question of 25 biomedical waste, dumping it in a water source, drinking water. What will happen to our society?
Not
And
discharging.
just for 25,000 lakh rupees, you are seeking stay and then again polluting.
We are not discharging anything, we are treating the lots as per the permission granted by the pollution control. We are not discharging anything.
You
my lord.
examine, Mr. their premises. In this petition, the petitioner has asserted the validity of the order dated 23/3/2023 passed by the National Green Tribunal, Chennai bench, by which it has been held that the petitioner, a medical college, is operating the hospital stroke medical college without obtaining appropriate permissions and sanctions, and the petitioner has been asked to pay a fine of rupees 25 lakhs.
Not petition, my lord.
Huh?
We are not asked, pollution control board, my lord, was asked to pay. We are not asked to pay fine, my lord.
Then why are you, you are saving pollution control board. Then why petition should be entertained?
My lord, because
Yes.
in the operative portion of the order, my lord, it was, we were pollution control, lords, may kindly see page 166.
183.
166, my lord.
6 is the order.
See, he is unable to even tell the facts, right?
Yes.
Fine was given on pollution control board, my lords.
So fine is on the pollution control board.
Yes,
They have not filed a petition.
They have filed, my lord, first, they only filed it first, my lord, first instance, they only filed it, stay was obtained. Subsequent, but respondent number 6, page 166, paragraph number 2.
Ah.
My lord, I'll read.
Delete. The petitioner is a medical college. In this writ petition, the petitioner has assailed the validity of the order dated 23/3/2023 passed by the National Green Tribunal Chennai bench, by which it has been held that the Telangana State Pollution Control Board has granted the consent improperly and has directed the Telangana State Pollution Control Board to pay the fine of rupees 25 lakhs. Full stop. The directions issued by NGT are reproduced below. Quote. So why you should not file an appeal? Paragraph. Learned counsel for the petitioner submits that the Telangana State Pollution Control Board had filed WP.
Yes, my lord, sir. Page
You
Triple
don't know,
171
Mr.
of 23.
171 of 2000. Page 179.
Triple 171 of 2023, my lord.
So
Page
Telangana Pollution Control Board had filed a writ petition MDWP number 1117.
171 of 2020.
1117
171.
1 of 23, in which an interim order has been granted by a bench of this court on 25/4/2023. In view of aforesaid submission, issue notice. There is no order of stay in your. Why you have not been asked to do anything? Issue notice. Learned counsel for respondents pray for and are granted. How much time?
My lord,
4 weeks time to enable them to file counter.
yes,
This is what you quote 165 page. Directions, no? 165, five direction.
The direction is to withdraw the complaints.
That's why there is not saying anything.
But,
You don't want to do anything in the matter, correct, Mr.
Lords may kindly grant.
Huh?
Page 181 order.
No, Praveen, what is the order?
What is,
The direction is to pollution control, levying penalty on that, that has been.
that has
paid.
been stated.
And the other conditions are withdraw, examine and withdraw the consent and all. How are you concerned with the order of NGT? Tell me. If the pollution control board initiates any action only.
They did not raise that pity. You are not an aggrieved person. Only so far as finding, perhaps if you are a party in NGT, are you? So therefore, the only thing is improper. That finding you are assailing here. What else? Rest everything is not a direction to you. When we said that 25 lakhs and all that, you did not even say that there is no direction. All right. Yes.
obliged. May I please your lordship?
Review for the position in order. It's 6th of September. Should be
Third on the question of admission notice.
But the first respondent is not a necessary party.
You delete first respondent Union of India. Learned counsel for the petitioner undertakes to delete Union of India from the array of first title. Let it be done today. You please do it. Issue notice to remaining admitted for hearing. Issue notice to remaining respondents.
I'm taking notice on behalf of respondent.
Whatever. He accepts notice. Issue notice to unrepresented. Get this thing. Get it. Delete. I will delete.
I thought that we have to send the help.
Quickly, madam. Now we have moved. Notice. Third on the question of admission.
Next is my lord.
Petition is admitted for hearing. Issue notice.
Item 6B,
Third on the question of admission. Petition is admitted for hearing. Issue notice. We are reasonable people, right? No. See. Yeah, we understand.
Medical batch.
This is which batch?
Seven.
Which batch?
100%.
We have read it, which number?
84,
84.
item number 83 to 85.
List along with item number 83. You madam, call along with 83. Right? Yes, 83.
Why ninth respondent is required?
No.
In one of the matter, they have also added seven, item 7 to 27, they have also included
Uh.
Andhra, some of the, why,
Yeah, not.
You have not, we will take it up at item number with along with 85. All these matters, 7 to 27 along with 25. 85.
20, 23, 22, up to 22, then we have 22.
Up to 22.
Then all 22.
23.
Lordships, 23, I am appearing in
Yes.
VC Lordship. I am
Yes,
appearing
yes.
for Arjun Kumar. This is pertaining to flooding, every year recurring flooding caused due to the construction of Kaleshwaram and downstream Polavaram project.
You are
Every year-
party person.
No, Lordship. I am an advocate. I have appeared this matter before Honorable Supreme Court also. Honorable Supreme Court
Yes.
directed the petitioner to approach High Court Lordships. Kindly see page number 102.
That so this is a different project.
Project is saying this is upwards. So the entire downstream got flooded.
All right. Heard on the question of admission, petition is admitted for hearing notice.
No blame.
Madam, 1 minute. Give 1 minute. We will write something. In this public, just 2 lines. The order is same facts we are writing, Mr. So and so heard on the question of admission. The petitioner claims himself to be a social activist and challenges the inaction on the part of the respondents in not taking preventive measures to prevent flooding stroke inundation caused by the construction of Kaleshwaram lift irrigation project. Full stop. The petitioner inter alia has prayed for direction to respondents to constitute an expert committee to assess the to enumerate the damage caused due to construction of Kaleswaram project and Polavaram project in so and so. Page 50 you will get prayer clause number B. As well as and various other reliefs. Paragraph case the petition is admitted for hearing, issue notice. Yes. Next. None had appeared.
Appearing for respond number 1.
Dismissal, right? None had appeared on behalf of the petitioner even on 3/8/2023. None had appeared on behalf of the petitioner even today. It appears that petitioner is not interested in prosecuting the petition. The submission made by learned counsel for the petitioner that the issue involved in this writ petition is covered by decision of Honorable Supreme Court in N.K. Bajpayee versus Union of India against the petitioner.
Respondent has.
The submission made by learned counsel for respondent that issue involved in this covered against the petitioner is placed on record. The petition is dismissed for want of prosecution.
Much obliged.
But as far as admission, 2 points not.
Huh?
The writ petition was disposed of at the stage of admission. Number 2 minutes, I'm constructing over 1+1 is construction. And for 60 square yards, no permission is required. Those are the 2 points for admission. Except the notice at page 39, I have not received anything else.
Yes, notice will be issued.
GHIC.
So this is grievances that without this thing.
One places you must.
All everybody is served, madam. So it has your grievances that the writ petition has been disposed of without hearing you. No notice served. We will remand the matter. No notice served. Take steps. No notice has been served. The office report indicates that the respondents had not been served. No, see, singular paragraph. No, beginning, write his name. Singular grievance of the appellant in this appeal is that the learned single judge has disposed of the writ petition by an order dated 12/9/2022 without either issuing notice to the petitioner appellant and without affording an opportunity of hearing to him. However, office report indicates that the notices have not been served on respondents in view of aforesaid. Learned counsel for the appellant undertakes take steps for personal service, proof of service, interim order continue.
Special.
Yes. Why it is come?
Well, in the last occasion, I passed on a minute.
Filing application, what? The filing number, not registered. Yes, Mr.
Well, in the last occasion, I passed on a judgment.
There is no material. We have gone through the averments made. So for sake of brevity, we will please come to para 5 of the petition. Para 5, page 11.
It is actually submitted, even though the cases are pending quite long time, no trial has taken place at the based on the third respondent, who is filing petition after petition to prolong and protect the trial.
What is the material? Order sheets, nothing. What is the stage of criminal cases? When they were instituted? Absolutely no particulars. You have to take this thing. We appreciate that you are relying on the decision of Ashwini Kumar Upadhyay, and there are directions. But before that, we will have to prima facie record a satisfaction that there is a delay in trial of case. For that, you have to produce the record, at least something, except for singular statement, there is nothing.
Kindly have a look at minute with great respect, page 9 on.
No. This is a query put to you.
Yes, minute.
So what is the answer? What is the material except this statement? You have to place some material on record. Then only directions by the Supreme Court will apply.
Lord, I will approach the minute, criminal court to get the minute.
Yes. Learned, how much time?
Next minute.
Learned counsel for the petitioner prays for and is granted 4 weeks time to enable him to make an application to amend the writ petition and to incorporate
Liberty may be given minute to.
whatever you first file amendment and this thing.
No, unless I will file an application to get the record from the trial court, then I was not a party to the proceeding. That is the reason the learned judge may not.
Third party affidavit you
Yes,
can file.
Obliged.
Procedure is there.
Yes, obliged.
Item 27 and 28, A. Ravindra Reddy, M. Praveen.
What is this matter?
The lordship.
I'm appearing for appellate in item 20.
This is obviously sponsored. Yes.
Your Lordship, I am item 27, Your Lordship.
Yes.
Your Lordship, item 27, Your Lordship. I am concerned, Your Lordship. Yesterday, respondent number 429 filed counter, Your Lordship. I will reply, Lord, adjourned, Your Lord, 2 weeks.
This is an appeal. What counter? Counter to what? Delay?
They have filed
192 days.
preparing for appellant in 28, Your Lordship. The respondent have filed a counter, they have stated certain facts
Counter to delay.
to stay petition.
Learned
Lordship,
counsel
it's
for,
not weeks.
it is stated at the bar that respondents have filed a counter to IA number 3 of 23 and IA number which IA 3 of 23 and 2 of 23 in view of aforesaid learned counsel for the appellants pray for adjournment to enable them to go through the counter and give the matter list after 2 weeks. Your presence is sufficient. Your presence is sufficient for them to seek an adjournment. Lighter vein, Mr. Nothing.
Only trying to learn, my lord. That's
Yes, so no, and we are trying to learn every day. Yes. Yes.
System dated for final planning.
Yes. Pleadings are complete.
Pleadings are complete.
You don't want to file any reply?
I filed a rejoinder.
Rejoinder. Then-
Lordships have directed for synopsis.
No, this has to be admitted. Petition is admitted for hearing. Pleadings are complete. Yes.
NDC on the last occasion, my lord, the respondent said they filed counter,
Not filing counter.
but in fact they did not file counter.
Respondent
Not
not
been
filed
served.
counter. If the respondent were not appearing, I filed a report.
Learned counsel for respondent number 5 submits that he has filed a counter. Let counter, if any, on behalf of remaining respondents be filed within a further period of 4 weeks.
Counter is not filed, my lord, by the respondent. Last occasion also they submit.
We have given further time to 4 weeks to remaining respondent. Nobody is also appearing, right? So it's very happy situation for you that ex party sort of thing. They don't want to oppose.
No, it is a case, my lord, where on the basis of a draft notification, my lord, NGT is trying to proceed with and passing further orders.
No. So counter has not been filed, right?
Yes, my lord, on the last occasion they submitted, they filed counter, which in fact is not correct. If the respondent says they filed counter. it
He is
is not
saying
filed.
so.
Now also I am
Not
saying I
filed.
filed counter report. Report filed.
Counter report.
Yes, my lord, filed.
You don't file encounter report, right? That will be frightening, right?
Report, my lord, filed.
You are saying counter report.
Report.
Tomorrow you will say, and that's why he is objecting that tomorrow you may say that I will file encounter report. What will happen to the petitioner then?
File report on 20.
Counter report, what status report is different than counter, what is new term for me? I want to learn what is counter report.
Not counter report. My
You
report.
said so.
Yes, my lord, counter is
He
different.
is saying, Mister, this is a pity that you are making a statement that you have filed a counter. He is saying that this statement is not correct.
Inspection report we filed, my lord, in the month of November 2020.
So inspection report, is it your submission that inspection report should be treated as counter? No.
Yes, my lord.
That they have filed, my lord, in the year 2020.
Let them, why should you worry? Let them not file. He is not saying he is so happy with the inquiry report, whatever report, survey report. We will decide it. The consequence in law is that all allegations are deemed to be admitted by them. He is not saying, he's standing up, looking at us, not asking for counter. Why should you worry?
No, because there is no interim order, my lord, they are seeking time.
So you say that this
That is
thing,
what-
we will hear you on interim order. What interim order?
The meanwhile, I'll file counter affidavit, my lord. This report is filed in the month of November 2022. Detailed counter, if it requires, I'll file.
What is this prayer, brother? Please. 30. Give, what state? It is, you are an encroacher. Who are you? What is the case?
But case is, my lord, in respect of a land, my lord, which is not a tank, on the basis of a draft notification issued by the HMDA, NGT, my lord, I filed this writ petition seeking writ of prohibition against the NGT from proceeding the matter.
No, so NGT, yes, please. 1 minute. We have understood it. NGT is proceeding on the basis of a newspaper report to deal with the encroachments on the lake in Mazi Banda, right?
Masjid Banda.
Masjid Banda. So you are an encroacher, you want that we should permit you to build a house on the tank and live
No.
there.
My question, my case is not. It is, my lord, so far as revenue
This
record
is the state.
shows, my lord, it is not a bond at all. Now draft notification is issued by the HMDA.
Go there and file an objection before NGT Chennai.
But I filed objections. I filed implead petition and all. But there is no final notification issued by.
And also, you will be heard by NGT. Why are you troubling us? The matter is, you have filed this thing. We go before NGT. We will direct the NGT to hear you.
No,
Yes.
NGT is hearing.
You file objection. Then why?
Yes.
See, Mr. Proceeding initiated by NGT. You are saying that this is not bund, etc., whatever. Not a tank, it is my house, whatever, whole area is my house, whatever it is. You have filed an application for impleadment before NGT and you are being heard. Why
Yes,
should
that
we
is-
interfere?
No.
You cannot invoke two parallel remedies, right? You have chosen one of going. We will direct that you will be heard
No,
in this writ petition.
No, my submission is, Lakshmi, kindly hear for a moment. I filed a writ of prohibition because NGT has no jurisdiction to proceed in the matter on the basis of a draft notification.
That
There is
you
no final-
file an objection.
I filed everything.
So you tell NGT that you don't have a power. When NGT adjudicates, then come. Right? You withdraw this petition at this point of time. Prosecute your remedy before NGT. Tell NGT that you don't have power. Supposing NGT rejects, then challenge it.
It is not rejecting, but it is passing peremptory orders, similar directing FIRs and other. Those
We
orders,
will direct NGT to consider your objection. Right?
those orders I have challenged before my lords. Let them file counter, my lord, because it is the question
No.
of jurisdiction,
No.
which we have raised.
They don't want to file counter.
That you, Lakshmi,
We cannot compel them, sir. He is not saying anything. He has filed a counter report and before he files an counter report, we dispose of the writ petition.
No,
This thing. He is expert in filing encounter reports. So be afraid of him.
Report,
Don't.
no, they are filing the reports.
No, this see, Mr. It may be without jurisdiction, anything, but everything and this thing can't be. We will direct NGT to consider your objections and pass appropriate orders.
because since it is the question of jurisdiction, my lord, the
Parallel.
is filed.
So then file a third petition before Honorable Supreme Court also. Why spare them? Prosecuted this thing because without jurisdiction. So I will file NGT, then High Court, then Supreme Court also. Go everywhere. File one in Bombay High Court also without jurisdiction. Go to Chennai, Karnataka, everywhere without
So
jurisdiction.
far as the matter is, my lord, pertaining to Hyderabad and
We understand that. We are trying to tell you that you cannot execute two remedies simultaneously. You are already prosecuting the matter before NGT. You have your objection is pending. We will direct NGT to adjudicate. Good.
No, my submission is, my lord, despite
When
my
did you file?
despite
When did you file objection?
no implead petition I filed,
When?
that is allowed, but and you, Lakshmi, kindly.
No, when it was allowed? When? When?
But the one.
Yes, right.
Till 24/3/2022, I filed, my lord, implead application.
Allowed when?
It was not taken on file. It was
Not allowed. You said allowed.
initially, my lord, and thereafter it was taken up, it was allowed, my lord. Matter was posted to
When allowed? You find out in the meanwhile, we are stating facts. In this writ petition, comma, the petitioner inter alia has prayed for quashment of proceeding, namely in OA number 3 of 2021 pending before the National Green Tribunal Chennai bench. The petitioner in addition seeks quashment of orders dated 25/11/21, 25/5/2022 and 1/8/2022 on the ground that the same is per se without jurisdiction. Paragraph. The facts giving rise to filing of this petition briefly stated are that on the basis of a news item on encroachments of lake in Mazid Banda, Masjid Banda Lake, comma the Masjid Banda village, comma National Green Tribunal Chennai bench has registered a suo motu proceeding on 25/11/2021 and has appointed a committee. Full stop. The Chennai, the National Green Tribunal
Item 24.
31D. 31D, no 31. Counter.
Terminal benefits.
Wait, I'm reprinting this one number. I
Huh?
got 31.
Huh?
Need to file the counter in this. Getting section need to file the counter in this
Huh?
case. We need to file the counter.
No, so
I'm
what should
reprinting
we
this
do?
one number
No,
one.
no, you need to file counter. Therefore, we start preparing the draft for your approval. No, you need to file counter, fine. So what do you expect that we should start
Just taking
drafting?
1 week time.
No, we should start drafting counter for you and file it, right?
Sorry, my lord, we will file the next data. At least 1 week.
How many years, mister? How many years? Practice.
4 years.
In 6 years, you will be entitled to come this side. Constitution only 10 years required. This the progress you have made. What will happen to senior counsel when he will argue
My
before you?
apologies, I am seeking the
Huh?
filing the counter, my lord. At
Huh?
least 1 week may be granted. My
And when,
apologies.
no, you will be sitting here, then senior counsel will say to you as a judge that he will say senior counsel that we need to file counter. Then what will you do as a judge? Tell us. What will you do?
My apologies.
After 4 years, you don't even know, mister, how to pray for how to make a prayer for filing counter. Need to file, don't file. It's not our case.
My lord, there is a charges are against level.
We are
against the
not parties.
petitioners.
We will allow the petition saying that all claims are admitted because you are
The
not.
respond number to
R2I file counter, my lord.
is a time for
R2I file counter. For respondent number 2, I have already filed counter.
First of all, he should stand there. He is coming here, and for petitioners, he is standing and saying that I want to file counter.
I'm sorry, my lord.
Unfortunate.
It's a time for
Lord.
filing of counter of the respond number 1. That's why I'm seeking the time for 1 week.
So
my lord.
you
Sorry.
did not seek time. You said we need to file counter. That's what the whole discourse is about.
My apologies. Before that completing my sentence, my lord. Sorry.
You have to pay. Ask him.
What is the total amount, Praveen?
My lord,
What is the total amount of terminal benefits he is claiming?
he claimed, my lord, sir.
5,97,000. Huh? And the writ petition is continuing, this is the second row.
He has been, my lord, he has belonged to not AP, my lord. So
Whichever state, both, we are putting this question to both of you. A person who is retired from service is being made from pillar to post for 6 lakhs rupees.
But there is a allegation against the level against the petition. Kindly see the page number 14.
Petition is admitted for hearing. Counter, if any, on behalf of respondents be filed within a period of 4 weeks, failing which appropriate order shall be passed.
Much obliged.
Nothing to be obliged. We are not happy about you. In the end, you did not say that how much time do you want. We have given 4 weeks time. Improve,
My
Mr.
apologies, my lord.
You come here to learn. At least learn how to make a prayer to talk to senior counsel. Sit by his side. He will guide. No, come there. Please come. He will tell. Not okay.
I will sit.
Not okay.
Item 32, stage was of GP for medical.
I am appearing for the first respondent, my lord. My lord, kindly grant 2 weeks time for filing counter, my lord.
You did not sit by his side. And you are talking to that lady advocate, right? Please tell him, senior, how to make a prayer for counter. Yes.
It's coming for counter of kindly grant 2 weeks time, my lord, finally.
Admitted for hearing. 4 weeks further time is granted to file counter. Yes. Yes, madam.
Or additional application.
May your lordship.
Counter.
Sorry.
File counter.
Lordship, may kindly see the December date 15th docket. Yes, I'm sorry, Lordship. Lordship, may kindly see the docket of
No.
15th.
What docket?
This is the fourth time they are seeking counter, my lordship. This issue.
Admitted for hearing. 4 weeks time is granted to file the counter. It is made clear in case counter is not filed, appropriate order shall be passed.
Much obliged, my lordship.
Yes.
Commissioner,
Yes, it is.
the matter where we not the HRC
Yes, respond number 2 has been served.
served and the counsel is appearing.
Not there. Interim order is there in your favor, right? Ah. What to do? Senior counsel for the petitioner. Petition is admitted
Lordship,
for
kindly
hearing.
publish. Kindly Monday without respondent counsel mother is hospital.
He is appearing for respond number 2.
Is proxy counsel, it seems the mother of the respondent's counsel is admitted in hospital.
Respond number 2.
Counsel for respondent number two's mother is admitted. Lordship, may adjourn.
All right. Petition is admitted for hearing. Learned counsel for so and so. Learned counsel for respond number 2 submits that the arguing counsel is not available on account of personal difficulty. List after 2 weeks, interim order shall continue. Interim order shall continue, then say list after 2 weeks. Yes.
Lordship kindly permitted me not, sir, requested 2 weeks time, 5 counters, in this. 35 it's 36 already 5 count.
35
Admitted for hearing, learned counsel for respondents pray for a granted 4 weeks time to enable them to file counter.
Much obliged.
In this case, Lordship, kindly see, my lord. Lordship, kindly grant 4 weeks time without filing counter. But it's as to
Petition is admitted for hearing. Mr. Prabhakar Rao, learned counsel for respondent number 2.
yes, Lordship.
Praise warrant is granted 2 weeks further time to enable him. to file counter.
Finally, my lord.
Finally. Mr. Prabhu. Let him first be out of 30th August, then you expect him to devote.
It is coming from since more than 6 months, my lord.
No, but you understand the importance of 30th August for Mr. Prabhakar Rao.
Yes, I understand.
Then lighter vein. Let him get out of 30th August, then he can only respond to your petition. 3 weeks, you make it 3 weeks.
Make it finally, my lord.
Fine. We will say, yes, we have said that 3 weeks time, finally. Or 4 weeks, finally. Yes.
And for the petitioner, asked him the learner keeping me that they take.
Learned counsel, let counter if any on behalf of respondents be filed within a period of 4 weeks. This thereof. Next.
Make the
Counter.
Provisions of section 25A of the CRPC is challenged at government.
Your Lordship,
Counter.
kindly permit me to represent Mr. Learned DSJ, your Lordships. We are kindly grant me 4 weeks time for filing counter, your Lordship. It has been sent for signature.
Learned counsel for respond number 1.
I am obliged.
4 weeks time.
I am
Enable her to file counter. Next. Counter, right?
May please.
Counter.
They have not filed.
Respondent Lordship can request 2 weeks time, Lords.
Learned counsel for respondents numbers.
2 Lordships.
May I
Two.
request for consideration of the interim prayer.
2. Praise warrant is granted 3 weeks time to enable him to file counter. Prayer for interim relief shall be considered on the next date of hearing. Yes. This password. Medical batch password. Call 41 to 56 password. No. First say 41 to 56 password. Then 57. We'll proceed like yesterday, no? So everybody else is free. 57. Why Balaji? Counter. Counter. Let counter if any on behalf of respondents be filed within a period of 4 weeks. 58. So what IS suspension
I
vacate
appear
stay?
for respondent, my lord, I filed a vacate stay application, my lord. Filed a vacate stay application.
Who appears for us?
Jitendra appeared.
next week or whatever. None for the appellant, Mrs. Learned Senior Counsel for Respondent. Let this IA 1 of 23 has been filed seeking vacation of the ad interim order granted by a bench of this court on 14/7/2022, by which it has been directed that the proceedings under the Public Premises Eviction of Unauthorized Occupants Act, Central Act,
State Act.
State Act, which whatever act, State Act is what year? State Act is of which year?
1971.
1971. May continue, but final order shall not be passed. However, the counsel for appellant is not present. Awaiting his appearance, hearing is deferred. List on 4/9/23.
Item 59 to 62, Muhammad Nasir, AP for Social Welfare.
This is government causing thing. What? Will adjourn it, none for the parties. List after week. Huh? 60.
I have responded.
63. Yes,
I am for respondent.
none for the appellant. Awaiting his appearance, hearing is deferred. List after 2. Interim order, if any, shall continue.
I'm appearing for contempt of appellant, your lordship.
Lords, I'm appearing for the respondents in this matter.
This
What
matter is
amendment?
taken up. after-
Amendment, you have any problem, madam? Amendment?
I have not been served with any amendment petition.
22 of petition.
Showing us returned, your lordship. Amendment petition is showing us a return. I'm appearing for contempt appellant, your lordship. It may be taken up after 2 weeks. Your lordship.
Lords, in fact, I had mentioned this matter because I filed a vacate stay petition in this matter. They've been enjoying the stay since last 3 years and they've not been compliant.
It
with the
is, your
orders.
vacating petition is not there. Which,
My vacate petition has got returned, my lords. I'll be complying with the objections.
then
Where it was-
why did you get a court slip unnecessarily?
I wasn't aware that it
Learned
would be
counsel
returned
for respondent.
for the respondents. my lords.
Respondent submits that she has filed a vacate petition. However, the aforesaid vacate petition has not been listed for consideration. Paragraph in view of learned counsel for the respondent submits that she will file a vacate stay petition. Where
I've already filed. It has been returned with certain objections.
shall file the resubmit, shall
Resubmitted
instead of
today,
resubmit vacate stay petition within a week, list thereafter.
Monday, my lords.
Madam, you submit, resubmit,
Correct.
let it be verified.
No, but this is gross abuse of process of court, that getting a case listed, a petition which is in office objection. That means you are totally non-serious.
No, my lords. In fact,
This is not fair. Fair.
it got returned just yesterday, my lords. I'll resubmit it today only, my lords.
You didn't know.
No, my lords, I did not know it, my lords.
All right.
I apologies, my lords, but it will
No
be.
apology. Yes. This is all waste of human effort.
I know the appeal for the
Order sheet
appellant
and
is
this thing. We will not grant you any court slip henceforth. We are watching everybody's behavior, right? We will remember. Yes.
My lords, in item number 66, I appear for the appellants, my lords.
Huh.
The respondent number 3 has filed that counter only today, my lords.
Huh?
I intend to file a reply, my lords, seeking
La-
2 weeks of time.
It is stated. Huh? First is speak, madam, into the.
Lordship, GP for revenue will be arguing this matter.
we
Request for
don't
a
know.
short.
No, what did he say? Have you heard what he said?
But whatever has been told to you, you have got it and you have to speak without listening to him. What did he say?
That we have filed the counter.
No, he said you have filed a counter, he needs to file a reply.
Oh. That I did not, your lordship.
So that's what you should realize, that even though you are physically present, mind is in the opposite building. Or if there is a building, I don't know.
My lords,
Learned counsel for the petitioner submits that the respondent number 3 has filed a counter today he therefore prays for adjournment to enable him to go through the same and to file a reply.
My lords, interim order may be extended, my lords.
1 minute. Interim order, if any, granted on earlier occasion shall continue.
Item 67, Virendra Singh, JQ Cooperation.
May I please? May I please? But in this matter, I am for the appellant. The vacate stay filed by the second respondent.
I have filed the vacate petition.
I request time.
Why?
I'm not ready. Senior counsel is there.
My lord, this is a vacate petition. My lord, Richard,
He knows.
you want a long time. Right.
My lord, 2 weeks.
No. This is not done, Mr. That after vacation of stay, you just not ready. We can ask very inconvenient questions to you why you are not ready.
Let's say next week. Will.
One night. Let learned counsel for the petitioner, learned counsel for appellant prays for adjournment to enable him.
May I please? Appealing for the appellate. Appeal is filed against the orders of the Leonard single judge Millard. The given orders were passed by refusing to register the agreement of sale.
So what should we do? The case is not that. Please argue, Mr. We are looking at you, not. It's your appeal, right?
Yes, Millard. My appeal is that only on the ground, Millard, that this document is not presented along with the Patadar passports, Millard. My submission is, Millard, that I am the expert holder.
Registration. So petition has been dismissed. Because they have not been able to.
We have not been able to produce the linked documents. We have not been able to produce the linked documents.
Arey, Mr. Don't expect us to argue the appeal on your behalf, right? We are asking you, please argue, you are not saying anything.
What happened, Millard, is the document was presented is an
Hey,
agreement
Mr.
of welcome GPA, Millard.
Which turn that switch to his mouth. Will you please somebody do it?
The document presented is the agreement of sale come GPA, Millard. And the objection that was raised by the registering authority is that it should be accompanied by the Patadar passbooks, Millard. And the act says that, Millard, it is only relating to the interest or title. Admittedly, the GP, General Power of Attorney will not confer any right. Even as per the circular that was issued by the second respondent is Millard.
You remember this was the coupled with possession.
Yes, Millard.
Once it is coupled with possession, why is that Patadar passbook not required?
What I submitted, Millard, that my vendor has not applied for the other passbooks, Millard, he passed away. And the legal heirs has executed
Will. All right. Yes. Anything else?
Yes, Millard. My humble submission is, Millard, that the document, if it is presented along with the Patadar passbooks, admittedly, my vendor has not applied for the Patadar passbooks, Millard. He died, and the legal heirs has entered into the agreement to come GPA with me, and it will not confer any rights, Millard. Even if the circular says it is an intermediary document, and coupled with the, subsequently the sale deed will be executed. It is not as if that sale deed is being executed and the right is stayed with me. It is only giving a power to represent the principal, my lord, that is the legal representative of the vendor. A vendor died in year 2004, my lord, he has not applied for the Patadar passbooks, my lord. And the registration of the GPA will not confer any right or creating any interest. And it is only relating to 6 million where the property rights are being vested or creating any interest on the property. Admittedly, Miller, no interest will be created by virtue of the power of attorney that was executed to represent the principal, Miller. And only Miller, unless single.
Yes.
Yes, Miller. Section.
Fine.
Section 6D to only relates, Miller, that the AP rights and land in Patadar Park. In not.
No, Mr. This is document is has been refused to be registered.
Yes, Miller.
On the ground mentioned, and you are saying that it is not necessary for you to produce that document. That we will examine.
Yes, ma'am. That is my because only on the ground that it is requires the Patadar passbooks accompanied with this document, Miller, that I am objecting. In fact, it is not necessary.
It is, it is admittedly agriculture land. It has not been converted.
Yes, Miller.
So once it is not converted, agriculture land, you need to attach the Patadar passbook because that is the title deed in terms of the provision.
Yes, Miller.
So unless until you challenge the provision saying it is arbitrary illegal, the refusal is right valid.
Submission is that.
No, that is what I am saying. Unless until you assail the correct validity of the provision and it is, unless it is struck down by the court, it is there in the statute. Once it is there in the statute, the authority is bound to follow it.
Section 62, Miller.
No, Mr. Raidu, please understand. The provision mandates that the title book should be there.
Provided, Miller, if it is in creating.
Unless until you show that this land has been converted from agriculture to non-agriculture before, therefore, the requirement specified under the Patadar Passbook Act does not apply. That is not the case.
No, my case is, Miller, the agriculture land is.
Once it is an agriculture land, you need to have Patadar Passbook.
My humble submission, Miller, the Patadar passbook has to be produced, provided if the interest is being created under this document.
If that is the case also, please go to page 45 and see what is that your clients are trying to create. It is an interest only.
No, sale deed is, it is not a sale deed, Miller. It is only creating that I should be authorized to represent the principal.
No. Please see, by virtue of this agreement comes GPA. The agreement is to sell the land to you and you have received the total payment is also made. Please look at clause 1 of the agreement, covenants of the agreement. Covenants of the agreement says the total consideration, agreed consideration is paid. So that is once an agreement or total consideration is paid, the interest is created. That's the reason he has considered it is not a simple GPA to represent you.
No, my humble submission is, Miller, that though the settle show, but the power that was given is to get this title cleared. Because the Patadar passbooks were not applied by the vendor, Miller, the legal aids are executing this document.
That is true. If that is the case, the legal aid should file GPA to approach them to get authorize you to get a Patadar passbook in their name. Not by executing a agreement of sale, registered agreement of sale, by receiving the total consideration.
For particular amendment, it's the MRO. They have not made the revenue department as party. After the amendment, it's the Tahsildar. Only the sub-registrar is made party and the.
No, because the agriculture land is the Tahsildar, which is the registering authority.
Yes.
So far as non-agriculture lands are concerned, it is the sub-registrar.
Yes. After October 22.
Yes, all right. Appeal is dismissed. Reasons to follow.
We will follow the reasons. Yes.
Which item, madam?
Item 60.
And I may be permitted, Millard.
60.
That is always there, Mr. Raidu. You don't need permission from the court to challenge. You can challenge anytime.
69.
69.
Item 69, your lordships, I appear for the state, your lordships.
69 to. Writing orders.
Ah, yes.
Your lordships, I appear for the state, your lordships, and the government pleader with the land advocate general, your lordships.
Huh?
I'm the government pleader with the land advocate general, your lordships. I appear for the state in item
Fine,
69.
Fine.
Your
So
lordships,
what-
the item 69 was, is listed on a request made by the state. An application by the IA number 1 by 2023 is filed to fix a plea hearing. Matter pertains to the Osmania General Hospital, your lordships, where the issue of demolition of the hospital is concerned, your lordships. These 5 restrictions, 2 of which are in favor of, 3 of which are
Demolition?
the structure, your lordships, insofar as it is a
Yes.
your lordships. 13/12/2022, your lordships.
This is for admission, right? What do you want? Early hearing?
Your lordships,
My learned friend says he filed an IA for early hearing in item number 69. Prior to that, I am permitted to make a submission in
How
item
we
number
know that this is?
74. I mean, appearing for the petitioner in item number 74.
Ah.
Earlier orders have not been complied with. But this pertains to Usmania General Hospital, my lord.
Yes.
My prayer is threefold in this petition.
This side, Mr.
First one is to preserve the old structure, heritage structure. Second is to construct as per earlier GO issued in the year 2010. Third is to maintain the sewage system and drainage system in accordance with the provisions of the Act. So far, they have not filed any counter.
your lordships, pursuant to the last order of the
No, Mr. What, I mean, what do you want? Without filing counter, you want?
counters are filed. No, your lordships, a status report has been filed. A status report dated 27/7/2023.
But please appreciate that you, I mean, if you want to argue, should you, I mean, we don't know whether your submission is that status report should be treated as counter to the petition. Because once we fix a date for hearing, learned senior counsel will say that these averments have not been denied by the state, therefore this heritage building needs to be protected, construction should, you should be asked to maintain that building.
I'll ensure the counters in all the restrictions.
Then you have to file first.
I'll file your lordships.
In fact, on 13/12/2022, a direction was given that the government may come up with a proposal keeping in mind the 2010 GO.
That is the status report that your lordship stating that it is not.
To file a comprehensive thing, right? This is, I mean, take a holistic view of the situation, right? This is a place where we are told that doctors sit with helmets. So
That
we were
is-
wondering
that is-
what happens to the patients, then are they given helmets also by the state government so that while taking treatment?
That is why your lordships, the status report adverts to the fact that the government is in favor of building a new hospital there. That is to be considered by this honorable court. Your lordships may fix any date, the land advocate general would assist this honorable court. This is the urgency that was pleaded and.
We don't know what they should do. Our difficulties, problem is that he's not even saying that he wants to.
I will ensure the counters in all the restrictions. Your lordships may consider.
You first
2
file
weeks.
counter.
I'll file.
Learned Special
special
government
GP with the
act,
land
special
advocate.
GP grace warrant is granted 2 weeks time to enable him to file a counter in the writ petitions. Replace thereafter. So we will take it up after, let them first file a counter, then the question of fixing the date. Yeah, of course, of course. So let it be. It's
Deeply obliged.
Much obliged.
May I please, Manoj? Manoj,
Yes,
this is the
madam.
matter, Manoj. This is the public interest justification.
Ah.
We have, filed, Manoj, for appointment of Chief Information Commissioner and State Information Commissioner.
What
in the
steps
state-
have you taken, Mr.
Your lordships, applications have been called for, 40 applications have been received for the Chief Information Commissioner.
One minute.
373
40 application for?
Chief Information Commissioner, your lordships. And 273 applications for the State Information Commissioners. A selection committee is to be called.
Members, no. The state information commissioners. They are called the state information commission.
273.
273.
Three.
So,
The selection
1 minute. So, chief election commissioner is one. How many members?
Members that.
Madam, how many members?
But it's 8 members.
State information commissioners. How many members? How many state information commissioners?
State Information Commissioners.
Keep-
Manoj, it is, Manoj, one Chief Information Commissioner,
Ah,
one State Information Commissioner.
ah.
And Manoj, members or Manoj, 5.
5 members. Huh? Yes, Mr.
Your lordships, a selection committee is to be constituted. I request some time, your lordships. I'll report back to your lordships on the progress of the matter.
When have you invited applications?
Manoj, they have filed a counter, Manoj, and
No.
material papers separately, stating that, Manoj, initially they have
No,
stated.
madam, this is public interest litigation. You will not be appointed as chief information commissioner, right? So we are asking you, that's why we are asking you the date on which, because he doesn't know.
Yes, Manoj.
So we are asking you the date because you are here to assist us.
Yes, sir. They made a paper,
See, I mean, the way he's turning pages, obviously he has not gone through it.
Your lordships, this matter was dealt with by my other colleague. That's my difficulty. I seek apologies, your lordships.
notification was made on, Manoj, 3/7/2020.
4/7/2023.
3/7/2023.
3/7.
Yes, Manoj. 3/7/2023.
Paper shows 4/7.
Hindu shows 4/7. Hindu, I'm seeing at Hindu.
Yes, Manoj, but the notification, Manoj.
What you have to constitute a committee?
Selection committee, your lordships.
Constitute.
It has to be constituted. I'll report back to your lordships. Lordship may grant me some time.
Some time means what time?
4 weeks, your lordship.
Time can be till
4 weeks, your
yesterday evening, tomorrow evening also 5 PM.
apologize, your lordships.
Sometime
Lordships may consider granting 4
So
weeks.
such a, this thing,
4 weeks.
subjective and vague thing, sometime.
I'm sorry, your lordships. 4 weeks.
According to you, sometime is 4 weeks is reasonable. See, she will immediately say this is too much. According to us, sometime, maybe some other time.
I apologize, your lordships. 4 weeks, your lordships may consider.
Be precise, mister. We are dealing with law. Precise and clear.
Yes. Request your lordships, 4
Not
weeks.
arts class, no? BA where you can write anything, whatever you feel like. Yes, madam, what is
4 weeks.
learned, whatever. You are government advocate.
Special GP with the land advocate.
Special. Fine. Learned special GP submits the issue in this
Obliged.
Lord, I appear for 1 to 4 minute. R1.
Huh? Yes.
But I appear for R1 to R4. But property, not any custody of any property. Using for purpose CRPF, it is under possession. The government of
No. So what you have filed counter?
the count is not filed. Now the parting person,
Huh?
the bill is filed.
No. This bill has been entertained, notice has been issued, your counter is awaited. So please, whatever you place it on record.
Packet 5, 6 and 7 will also file count.
1 to 4 I have here.
Mr. Praveen Kumar, TSGI as well as GP for revenue.
5, 6, 7. Response
5, 6 and 7. Pray for and are granted. 4 weeks time to enable them to file counter. List thereof.
District council requested for next week last.
Huh?
Sir Srinivas requested for next week last.
What is the petition about?
Sorry, Lordship.
You don't know. All. Will admit it. What is it? Counters has been filed?
Yes.
Petition has admitted for hearing. Let counter be filed on behalf of the remaining respondents who have not filed the counter so far. Huh? On the batch. Medical batch 7 to something, no? Which? 81. So we'll call this medical admission. Part third.
All under the prison that should be counted.
2:30. No. They will come now. Yes. Number you should show.
Yes.
Print out you have given, no? PLN. Okay. So you have concluded, Mr. Rao. 1 minute, let them, I don't know, you are showing the number? It's being shown?
Number is being shown.
Okay. You can, these people are required in court hall 1, you can.
That's
Message.
Yes, the councils are appearing in.
Are required. They were waiting since 10:30, the part 30. Yes.
Lords may kindly see, Lord,
So just tell us, I mean, till they come, I mean, they may have.
Lord, the requisitions are filed questioning. Rule 3, Roman 3, Lord, small b, small b of capital B, Lord.
Flags are smart.
Lord, though writ petition is filed questioning the GOMS number. Lord, your lordship was formulated, Lord. GOMS number 114 dated 5/7/2017, but it was consigned to Lord Rule 3, Roman 3, small b of capital B, my lord.
Roman
3, about the 3, Lord, lordship may kindly see Roman 3, Milord, capital B, A Lordships.
Capital B, again B. Small
A and B. Milord, they are relying upon B Lordships. A and B. Milord, Lordship may kindly see, Milord, page 19, eligibility criteria. Eligibility criteria, page 19, Milord, rule 3, A Lordship, please.
No, what is your submission then?
My submission Lordship says, Milord.
Then we will see rule, etc. Submission, what?
My submission Lordship says, Milord, under the rules, Milord, the candidate who seeks local status or non-local status required to satisfy
Candidates who
seeks Milord status of local or non-local required to satisfy Milord, the clauses framed under presidential order
non-local candidate
are required to satisfy the presidential order, Milord, that is Milord, the 1974. Milord, Rule 3A, Milord, it is stated, Rule 3A, it's specifically stated, Milord, just I read, Milord. Nationality, domicile, the candidates should be Indian national or persons of Indian origin. Overseas citizens, cardholders should satisfy local, non-local status requirement as laid down in the Andhra Pradesh Education Institutions Regulation of Admission Order 1974
rule
as amended in GOMS number 646 dated 10/7/1979. Milord, Rule 3, Roman 3, capital B. Milord, is a parameter area with the presidential order.
Now that you have argued yesterday.
I just read, Milord, for your lordships. My benefit, Milord, I just read.
No, for our benefit also.
A and B, lordship, A and B. Milord, A is lordship, please. I just read, Milord. You have studied in education institution in such local area. In such local area, as Milord, I stated so, Milord, yesterday, there are 3 local areas. If you have studied in such local area for a period of not less than 4 consecutive academic years, ending with academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying exam, then you will be treated as a local candidate in a local.
Where are counsel for petitioners? They were here at 10:30 when the case was called. We told them it's.
But some of them are there. Prabhakar is there, Milord.
You are there, no, mister? You are there, no? Paul, where are senior counsels? They are. Make note of what he is arguing, mister, and tell senior counsels by the time you also make note. So, how much time will you take? We thought that you concluded.
Just 15 minutes, sir. 15 minutes.
Okay.
B, Lordship, kindly.
Yes.
B.
Rule
Page 21B, small b.
small b.
Where
There are 2B.
A, not A and small b. In a capital B, there is A and small b. Not page 20, bottom, Milord, capital B. I just read, Milord, A losses.
Where whole or any part of 4 consecutive.
Yes, sir.
Read.
Whole or any part of 4 consecutive academic years, ending with academic year in which he appeared, as the case may be, first appeared, for the relevant qualifying examination, he has not studied, this is important, he has not studied in any educational institutions. If he has resided in that local area for a period of not less than 4 years immediately preceding to the
date of commencement of the relevant qualifying examination, which he appeared as the case be first appeared. Right. In this clause also, one can be satisfies your local status provided that he should be resident of such local area
And
or constitute
not study.
not study. That's not study.
We have noted down yesterday.
That's exactly what the GOMS number 646 class 4 says. Not studied. The study is only in relation to, let's may kindly see, educational institutions which are recognized by the state government or central government. One who has studied the 4 consecutive academic years, the study should be confined to the schools, colleges which are recognized by the state government or central government. That's presidential order says. That they in other words, they are challenging rule 3, Roman 3, capital B and A and B and C. They are challenging. In other words, they are challenging the presidential order. That the validity of the presidential order is upheld by the Honorable Supreme Court.
That you didn't tell us, huh? That was the
Yesterday, that Sureka case. Pair of filers.
Paragraph?
Filers. That the only other question that survives for consideration is as to whether within the presidential order 1974, the scheme of Pradeep Jain case can be worked out. The presidential order of 1974 defines available seats and local area as also statewide educational institution. Subclass A, B, E of class 2, class 3 describes 3 local areas. Class 9 gives overriding effect for the presidential order. Under the presidential order, admission to educational institutions is limited only to local, non-local candidates. It does not contemplate of admission into educational institutions otherwise. The contention of Mr. Chowdhury that if a presidential order has got to be given effect to its true spirit, the scheme in Pradeep Jain case cannot be consistently with the presidential order be implemented, cannot be brushed aside, and bears serious examination on certain important aspects. If the 15% seats are not treated as reserved in terms of the presidential order and are intended to go to those who qualify all India entrance examination, it is stateable possibility the presidential order might be diluted. It may be doubtful if in ascertaining the import of available seats would be permissible to deduct 15% of seats for non-locals applying the formula of Dr. Pradeep Jain case. We are inclined to think that the contention advanced by Chowdhury on behalf of the respondent state that within the ambit of presidential order, scheme adopted by this court in Pradeep Jain case is eminently arguable, raises that important issue. It is, however, it is not necessary to pronounce on this question finally, as the petitioner admittedly has already been provided admission in one of the medical colleges. Before we part with the case,
It has not
we
been
would, however, like to indicate that the scheme of Dr. Pradeep Jain case.
not answered, Mr. Rao.
Yes, that's
That's not a ratio
let's me kindly see.
because admission was given.
I guess there are 6 lots.
Yes, thank you. This is actually it's the victims. This is petitions based. There is a special case. Don't decide. You can do it.
This course of action, Mr. Rao, on the lighter side, this course of action is still available to you.
No, that's
No, in this case, the candidate was given admission. the course of action, which may be, we are not suggesting anything, perhaps you can say that we will consider the case of all the petitioners as local candidates
In the last year.
last year of this thing, and it should not be treated as precedent, plus please do not examine the validity of this provision. You can say so, like this case. So therefore, the court will say, like Supreme Court has said, that is not necessary to answer.
Right. Lords may kindly see, my Lord.
So therefore, this is not the ratio, right?
Well, Lords may kindly see, my Lord. Lord, the main paragraph, Lord, the Article 371D, you see, Article 3 is not open to challenge on the ground of being unanimous to basic structure of the Constitution.
Which para?
Paragraph 4, my Lord. I read 5 and 4, Lord.
But you read 5. Yes.
But paragraph 4, we learn last from 10 lines. This court came to the clause 5, which provided the final order in the administrative tribunal shall become effective of its confirmation by the state government. It was open to the state government to modify or annul that order within 90 days, militated against the doctrine of basics. At the same time, the court held Article 371D was valid, intra vires, and amending powers of the parliament. This clearly means that our scheme of 371D was valid and provision in clause 5 alone was bad, and clause 10 of the Article 371D provides the provisions of this article and of any order made by the president thereunder shall have an effect notwithstanding anything in any other provision of the Constitution or any other law for the time being in force. In view of the terms of clause 10 and the effect of decision of the Constitution in Sambamurthy case, the petition is not entitled to any relief on the first ground, namely for declaration that Article 371D militates.
So validity of Article 371D was upheld. In some other case to which reference has been made.
Sambamurthy case, where the Constitution made. Where this presidential order was made pursuant to the Article 371D.
No, correct. So therefore, it is not correct to say that validity of presidential order has been upheld. You can say that validity of the source of power from which the presidential order emanates has been adjusted and it has been held to be valid.
Yes, sir.
That's it. That's it.
Yes.
Anything else?
One sufficient. Let's see, says minutes.
Which is
What treatment you have given to this GO for the previous academic years, Mr. Prabhakar?
That is GO 1772 is not
This GO 114, the same clauses. This was issued on 5/7/2017.
Yes, sir.
So how you have given effect to this for the academic year 18/19, 19?
18/19, all the candidates where the interim +2 or 9 and 10 who are studied outside the state, but they were treated as non-locals. So they were treated as non-locals.
So consistently you have been.
Yes, sir. Exception is only, my Lord, the order passed by His Lordship Justice Ramasubramanian, my Lord. That's all, my Lord. In any case, there was no deviation.
For the in the academic years 18/19, 19/20, 20/21, 21/22, 22/23.
Yes, sir. All these years.
Except court orders.
Except one court order. Except only one court order.
That is 17/18 or 18/19?
17.
Huh?
I'll take your lordships to the judgment.
That senior accountant we didn't see today.
with computer too, so we said that the way
What is this? We didn't say, but we only told Mr. Mayur Reddy that it will be passed. Mr. Mayur Reddy.
That is lordships.
Madam, you are showing Mr. Mayur Reddy is required.
On 18/19. That's
total one.
Please.
Mayur Reddy and everybody is required. Tracker shows.
Tracker. Ask them to show that Mr. Mayur Reddy senior counsel is.
No, is it required in this thing? Code one.
Call number 1.
Why you are not showing this?
Ask them that.
track, they show this also that
Council so and so and so.
Mr. So which year, Mr. Rao?
That is 2018-19.
One case.
Okay. 2022 similar issue was arisen. Page 58, this honorable division bench of this honorable court, following full bench judgment.
That you told us last evening.
And the Andhra
Andhra Pradesh also followed full bench.
The full bench is governing the issue lordships.
All right.
In view of the full bench judgment, that they are not entitled to be treated as a local bank.
That's it, Mr. Rao.
That's
1 minute.
Only one case here.
One.
The other cases have to be dealt.
Para 39, you write. On the other hand, Mr. Prabhakar Rao, learned standing counsel, submitted that under the rules, or under the impugned rules, comma, the candidates who seek status of local or non-local candidates are required to satisfy the requirement in presidential order. It is further submitted that the impugned rule is in peri materia, is peri materia with clauses 4 and D of the presidential order, right? Then para 40, this is substituted, right? Para 39 substituted, para 49 here, para 40 here, this one. Learned counsel, standing counsel has referred to decision of in support of aforesaid submission. Learned counsel for respondent has referred to decision of Honorable Supreme Court in so and so. In Dr. C. Surekha versus Union of India and others, 1988, Volume 4, SCC 526. Then paragraph then 52, last line. Learned counsel for it is also contended that the rules have come into force since 2017 and have been applied for all the academic and have been implemented in this implemented for the academic session 2018-2019 till 22-2023. It is further submitted that that relief was given only to one candidate in pursuance of an order. Where is that, Justice Ram Subramaniam? Pursuance of an order, relief only to one candidate.
This one.
Relief only to one candidate was granted to one candidate, namely Vasagiri Sai Nithwa versus state of the one candidate, namely so and so, in view of order dated, interim order dated 6th of July 2018, passed by division bench of this court in WP number 23160/2018 within bracket Vasagiri Sai Nithwa versus state of Telangana and two others.
But you filed an application for vacate, but this honorable court declined to vacate on the ground that he is pursuing. But this also not speaking.
That is this Lordship Justice Sanjay Kumar.
Yes, that has been told you. It has been cited. That's it. Complete now. Incorporate these changes and give me a printer. Another we will now record. but there's nobody to argue. Yes, Mr. Petitioner, it's your moment now in the absence of senior counsels.
But I would
They
like
are
to,
not appearing, they don't want to give any rejoinder. What can be
I
done?
have messaged one of the seniors, but
Then, it's not this our job to wait. We are not seeking admission to MBBS course, right?
Yeah.
None of us wants.
Item number 42 and 50, Senior Counsel Mr. B. Mayur Reddy is appearing. I have informed he is rushing towards the court.
Let him rush. He was here and we told that we did not. See 526 and have told us, Mr. Reddy, listen.
Yes.
We are telling you what he has argued for 5-10 minutes, saying that the validity of presidential order has been upheld in 88 volume 4 SCC 526, and these rules have been implemented like this from academic session 2017-18 till today, except in case of one candidate who got an interim order by a division bench of this court. And the other submission made is that under the rules, the candidate who seeks the status of a local or non-local candidate they are required to satisfy the requirement of presidential order. And yes, virtually he had concluded yesterday only these two things.
Yes. I was under the
Fine, now no impression.
I'm so
It's
sorry.
reality.
Yes, yes.
Rejoinder.
I was under the belief that
Petition.
Mr.
So we wondered, we never said that we will take it up at 2:30. We never said. We hurried up with other cases so that we can.
I had asked.
It appears that we are seeking admission to NEET UG course. Mr. Rao gets that impression. He will issue special orders for both of us. In which college? Gandhi Medical College, Hyderabad.
that is a premier college. That is a premier college.
Premier college. Mr. Rao has agreed to admit both of us.
Seeking getting that territorial army.
Territorial for the purpose of territorial army. Go ahead, Mr. No impression.
My lords may be very young, but not so young for being students.
Of course, there's nothing, no end to learning. We don't want to share what all ages of people, what they are doing. Yes, go ahead, rejoinder.
My submission, is that the entire construction of the respondents appear to be that the rules originate from the presidential order. Now the president, my understanding, though that presidential order cannot be challenged as per the Supreme.
So, Mr.
I'll just
one minute. So, therefore, rejoinder submissions you formulate, then elaborate. We have been repeatedly telling.
Yes, that's what I'm trying
to do. Number one.
My whole endeavor is to
1 minute. Tell us what is the sum. You can elaborate.
Yes, madam. My submission is that the rules, the origin of those rules is from the Telangana Education Act, which your lordship were to see at page.
All right, rules enacted under the
Act. Lordship may see, yes. The act originated.
Just a minute.
The act originates in the exercise of the legislative power of the state. That is, as is evident in the state enactments beginning also. It does not refer to the presidential order.
Which entry under list 2?
The entry.
That is your submission, right?
Yes, yes.
Which entry? Find out.
Yes, yes,
Tell us.
yes. Now,
Ask your colleague to find out
Yes.
under entry so and so of
Yes.
list two.
in a moment, yes, my lords, I'll do that. Now,
So what is the next submission?
therefore, it is possible for the petitioners to challenge that portion of the rules.
Permissible.
Yes, yes, my lord, permissible. Constitutionally permissible, my lords,
To challenge the rules.
and for your lords to review it. Because
Of course.
there's a bar with regard to that,
Yes.
the Supreme Court judge.
Yes.
That does not happen.
And we tell you, Supreme Court does not decide about this thing, validity of presidential order.
Yes, it only says,
Supreme Court does not decide about validity of presidential order.
in fact, in the judgment cited by my learned
1 minute.
the
Then
presidential order, when it fell for consideration, the Supreme Court said that we hope the time will come for the legislature to do away with that. And as Justice, Chief Justice Deepak Mishra said so in that order. He does not say that it cannot be challenged at all.
So you are saying that Supreme Court in 1988-4
Yes.
did not deal with the validity of the presidential order.
But only said that.
No.
Yeah.
This is something in your favor, Mr. It only says Article 371D is valid. That we told Mr. Rao.
Yes. But we are concerned with the orders under 371D. To stretch that.
So that's why presidential validity of presidential order has not been upheld by Supreme Court.
Yes, sir.
Then
Yes, therefore.
No, Mr. Reddy, as we have got it, if we have got you correctly, what you say is that rules have been framed under the Act. The Act does not owe its origin to Article 371D, but is enacted in exercise of powers under some entry of List 2 of 7th Schedule.
Yes.
Therefore, it is permissible for you to challenge the rules.
Yes.
Number one. Secondly, 88 Volume 4 SCC 526 doesn't decide about the validity of the presidential order.
Yes.
It only upholds the Article 371D.
Yes.
That's it.
Yes,
And then
including
next.
2016 2 SCC 328, which has been cited by my learned friend.
2016.
2016 2 SCC 328, which has been filed with the vacate, wherein they say
He did not refer.
He did not refer, but
Why should you refer?
yes, I won't. But it has been cited.
Don't
Yes, yes.
meet his submissions, right? This is not de novo argument.
You know, yes. So what my respectful submission.
What is next submission?
Therefore, my lords, it is within the ken of this honorable court to review the validity of that 3.
Yes. Then next.
Capital B. My lords, and my respectful submission therefore is that since that can be done, what we are seeking this honorable court to do is that
to read down.
Is that applying the principle of harmonious construction.
He said reading down.
Reading down. In a manner of speaking, that's what I'm submitting.
No, these are harmonious construction is different principle, Mr. Reddy.
Yes.
1 minute.
Yes.
Harmonious principle may not apply in the facts of the case. Harmonious applies where there are two apparently conflicting provisions, legal provisions. Therefore, the court applies the principle of harmonious construction so as to bear in mind the object of the act. This is not the case. It is reading down.
Yes.
That is what
Reading down.
Bombay, this thing and Supreme Court said. But Bombay High Court has applied that principle.
Yes.
Division bench.
By applying, what
Reading down.
Yes, ma'am. What I submitted is
Therefore, rules should be read down.
rules be read as a whole. If it is read as a whole, Lordship would see that just 3 capital 3 C, that's C. A,
B3C.
yes, BC. Those provisions, the impugned provision has to be, as has correctly fallen from this bench, to be read down in the light of these provisions, this provision.
Which provision?
This, which fell for interim order of this court, that is,
No, Mr. Again, Mr. Reddy, we may tell you,
yes,
principle of reading down would apply to a case where you are able to make out a case that a provision of law is arbitrary, violative fundamental rights, something like that, suffers from some infirmity for which it is liable to be struck down. So instead of striking down that provision, because it is a it is a legislative will is manifest intention of people. The court interprets it in such a manner, reads it down so as to bring it in conformity with the constitutional scheme of things. That is the DTC Mazdoor Sabha 1991 Supreme Court. None of you have cited that judgment.
must preserve the validity.
So when they have dealt with how and when the principle of reading down can be applied.
Yes, that blue pencil rule and all that.
Your blue pencil is different, Mr. Blue and red pencil doctrine is different.
Well,
You are confusing.
yes.
So we will give you 15th edition of Principles of Statutory Interpretation. Blue pencil doctrine again is Mr. different thing. Supposing a rule, this is not a interpretation class, right? So, like where two provisions are there, rule contains two provisions supposing A and B. A is valid, B is invalid. So blue pencil doctrine would and red pencil doctrine would apply. The offending portion of a rule can be segregated.
In a manner.
So we don't know blue pencil applies. Again, blue pencil doctrine, I have a delivered judgment in Karnataka. It is in fact nothing, we have followed Supreme Court. Honorable Supreme Court has laid down that principle. It's already there.
It's already.
No. So which part has to be excluded according to you?
No, this portion.
That's a different argument, Mr. Reddy,
Yes.
which you have not made.
Yes.
Different argument that this portion of the rule is valid, this portion is invalid, therefore blue pencil doctrine. Not the case here.
Not.
You are banking upon Supreme Court judgment that this thing, Delhi thing,
Yes.
and Bombay High Court, and saying that reading down. Read down.
Read it down.
Be sure on this.
Yes.
Don't try this thing, blue pencil is not there, not applicable. Next.
The other portion which I tried to place before your lordship is the reference to the full bench. I made a reference, my case was never that the rules emanate from the presidential order, and therefore because the rules are in any way with regard to that only discussion I had with regard to the presidential order was only to show that the full bench order, my lords, refers to the presidential order. My only endeavor was to show that even the full bench order, my lords,
You have said full bench doesn't apply.
full bench doesn't apply. Why? Because, my lords, para 45 of the full bench order, which is in my friend's vacate at page 56 and 57. My lords,
No, why it does not apply?
why it does not apply, I am coming to that.
You have already argued.
Yes, but portion of my argument as to why it does not apply may require 1 minute.
Of course.
Yes, but what I'm trying to submit is page 56 and 57 clearly is, my lords, the full bench examines the scope of the presidential order, which is at page 15 and 16 of the vacate, only with regard to residence, not with regard to study. Lordship may please see.
Where is vacate?
Yes, the vacate.
Page?
Yes, ma'am. The vacate.
No, 56. Page.
Page 56 and 57.
All right.
Fine.
Yes. Why it does not apply?
Para 43. Para 43 is with regard to that 4 years. 4 years. And para 44. Para 43 is with regard to 4 years. Para 44 or 43 is with regard to 4 years. 44 is with regard to the specific fact situation.
45 is important. 45 only examines the scope of the presidential order with regard to residence alone, but not with regard to what bylaws have examined in the interim order. That is with regard to the majority of that 7 years being studying here. Full bench only examines residence. I'll just read it. However, a candidate who is not regarded as a local, a candidate under Rule 4.1 can be treated as a local candidate under subparagraph 2 if she fulfills either clause A or clause B. Again, clause B is applicable. Lordship, please see. Clause B is applicable only to candidates who have not studied in it but have resided in the state for a period of not less than 7 consecutive academic years immediately preceding the date of commencement of relevant qualifying examination in which he or she appeared or first appeared. Since the petitioners have not studied in educational institution, she doesn't come under this clause. This clause, which is being examined at para 45, is at page 15 and 16 of the vacate papers, Manoj. In page 15 and 16 of the vacate, they have only examined the applicability of clause 4 to B, which is at page 17. This is a pledge.
Number 2B.
Yes. Or number 2,
B.
clause B. With regard to residence, please see 7 consecutive years that discussion. There not
Page.
yes.
Which para?
16, 17 of the vacate. This is the presidential order. Page 16. Yes.
Yes, if during. Correct.
That fellow. If during the whole or any part of the 7 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared for the relevant qualifying examinations, he has not studied in the educational institutions in that local area. That is for a full period of 7 years. He should have resided and studied, but has resided in the state during whole of the said period of 7 years, be regarded as a total candidate in such local area where he has resided for the maximum period out of the set period of 7 years. This is what has only been considered by the full bench in its operative portion at para 45. And then they come to the conclusion in the succeeding paragraphs. And then say the candidate has not resided in the state of Telangana 7 years prior to the examination, qualifying examination. Therefore, he doesn't fall under that clause. Therefore, the full bench says that the writ ought to be dismissed. But what your lordships have examined in the rules is seen in the presidential order at page 16, bottom portion. Page 16, bottom portion. That is 4 to I, bottom portion, which is para materia to the rules. Merely because the presidential order is similar to the rules, it doesn't mean the rules come out of the presidential order. That seems to be the argument of the state. But please see, for clause 4, fellows, a candidate for admission to any course of study shall be regarded as a local candidate in relation to a local area. 2, a candidate admission to any course who is not regarded as a local so and so. Please see I. It is this I which fell in the rules on the basis of which my lordships gave an order. Such local where he studied for the maximum period of the set period of 7 years. Whereas the full bench is silent with regard to this clause's examination. But that clause was noticed by your lordships while granting the interim order. If your lordship were to see the interim order, your lordships have seen the rules, para materia which this clause, exactly similar to this clause, and then said, this clause says 7 out of 7 years if he has studied for a maximum period in the state of Telangana. Those rules. Page 25. Page 25, my lords may see, in the main material papers.
నాది నా నోట్ ఏది? Okay, like that. Well, therefore, my lords may just for a moment. That parimateria, I'm so sorry. So sorry. I'm sorry. The entry of, yes.
Education matters.
Entry 66, see around 66.
Yes.
Entry 66
Yes.
of list 2.
Yes.
Education, Mr.
Education. I'm just looking at
62. List 2, 60.
Entry 66 is fees in respect in any matters of this list, but not including fees taken in any court.
Oh, this is residual. Residual. Education is there is an entry around 25. See 25.
My lord, it is entry 35 of list 3.
Yes. You're seeing the residuary. Yes, ma'am.
Been permitted, my lord, by the
Education.
second amendment.
Education.
Education, including technical education, medical education.
What under entry?
That is list 3, entry 25. I'm obliged. The residual.
Entry 25, I was saying list 2, it was list 3. Correct.
Yes,
So 1, yes.
I'll just read that.
1 minute.
Yes.
All of us are reminded of our school days when we hear this sound. No? We had this thing, not like modern day things where so nice.
Maybe it is to remind us that we are all still young ones.
Young and learning every day. Students in law learning everything new. Yes. So you were referring to Mr.
Referring to page.
So what did you say then?
That same clause which your lordships have seen at page 16 of the presidential order at the bottom.
Bottom.
That is the same.
AI.
It has been repeated in lordships I've just seen. Page 25. C.
25. 25.
Yes, page
of their vacate petition.
Of the main writ petitions.
No, that is, we are referring to the GO 114.
Yes, madam.
Now,
The
which
rule.
clause, page
Yes.
20.
Page 20, we have got.
Right.
Yes.
Page 20. Which clause in?
Yes. Clause 3, Roman numeral 3, B, I'm sorry, C, small a.
1 minute. One minute.
Yes. Well, therefore, if your lordship were to see page 25, 3 Roman numeral 3 CA at page 25. Yeah.
See, 1A or 2A?
Not 2A, 1A. Also 2A also your lordship may see. They are both not fallen for consideration. They were also there in the presidential order, but were not falling for consideration by full bench. So if your lordship were to see C1A, such local area, as I'm reading at page 25, C1A, such local area where he, she such local area where he, she has studied for the maximum period out of the set period of 7 years. This is same as the presidential order at page 16. That is 4-2I. Same. With regard to study. Now, with regard to residence also, lordships are, as noticed in the interim, C2A.
So what you said, C1A and
C2A also.
Ah,
Studied and also researched.
C2A not considered by full bench.
No. That is for presidential order 4-2I, not considered by full bench. This is
And your cases alternative is C2A, you are already there.
that was never, and in 4-2I of the presidential order never fell for consideration before the full bench. 3 C2I is para materia to 4-2I of the presidential order.
C2, C2I,
C2I is
C2A.
C2, yes,
A.
yes, C2A. CIA and C2A. Yes.
IA is with regard to study.
Yes.
I2A is with regard to residence.
That is para materia to lordship may see page 15 of the vacate.
No, paramaterial to what?
The presidential order.
Which clause?
Which clause with 4-2I. 4-2I and 4-2BI. I'll just
4-2I.
4-2I and 4-2
BI, small bi,
Small b and small I,
small,
separate,
yes. 4 to
correct.
B is with regard to study.
Which page?
That is at page 16, 17 of the vacate.
Or correct.
Madam.
Then
So what we therefore say is, these clauses never fell for consideration for the full bench, which is at page 56, 57. 56, 57 only examined 4 to,
correct, correct.
yes,
So full bench is not a authority for this so far as interpretation of these rules are concerned. Correct.
has only examined 7 consecutive years a candidate should have recited.
Therefore, full bench is of no assistance to
So,
respondents.
yes, because this is clearly evident at para 46 of the full bench order.
No, you don't like give us proposition next. Then
So therefore,
full bench is therefore not no assistance.
that distinction has to be made, Madam.
Yes.
Because of,
We will continue.
yes. Yes.
We'll continue after the break. So virtually, I mean, you have put it nicely. We have got it, everything.
So,
So, what is the other proposition? Just before we can you can formulate and tell us.
Yes.
We will hear you, of course, after the break.
the other position is with regard to this clause 11 and that illustration which has been shown by my learned friend with regard to government officials, applicability is only 15%. Our submission says that is not a correct argument because that clause is with regard to persons who are natives of other state. Who then
That's it. Clause 11 does not apply.
clause 11 because they become,
All right. So that's it. And another thing.
yes,
Anything else? We will hear along. We will go through along with you.
yes,
Just curiosity. Anything else? That's it.
that's it, madam. Just I've just lost my point page in these papers, but
Yes. No, you have this. So we will hear you on these 2 points after the break.
Subject to my lord's permission, my lord. I apologize, my lord. Item 24, it's a party in person matter under dismissal caption. I couldn't appear when the matter was called, my lord.
So it
Lordship's
has disappeared. We have passed the order. We don't change it, mister. This practice is, you don't have system of restoration here.
Yes, my lord. I'll do the needful, my lord. I'll do.
See, mister, supposing if you argue a case, we grant stay. At 140, we change the order. Dismiss. What will you say? It's all the counsel in whose presence it was dismissed has gone away. We can't alter behind his back.
Yes, yes.
No assistance.
That point to which.
Two other points, please tell us.
Just before the new point, Melons, with regard to the point which I
We will.
concluded on, with regard to that point which we concluded on, tagged along with the full bench, the state had relied upon two division bench orders, one of this honorable court and the other of AP
Andhra Pradesh.
to buttress their proposition that the full bench having been followed by our division benches recently.
Yes.
That concludes the point and there is nothing further to argue on that. Well, the only submission I were to make is
Two other
that since
points,
the full
please tell
bench,
us.
just before we have argued that point, fellas, with regard to the point which I present concluded on, because with regard to that point which we concluded on, act along with the full bench, the state had relied upon two is parameter order, one of this honorable court and the other of
Andhra Pradesh.
clause 3 to buttress their proposition and that the full bench act has not fallen for consideration in full bench. Now, the two division bench orders.
Consequently, no precedential value.
Yes, with great respect, have not actually given any holding independent to what the full
So,
bench has
Mr. If
said.
we can sum up your submission is that neither full bench
Yes.
nor division bench of this court and division bench of Andhra Pradesh High Court has any precedential value.
Precedential
Right? Because the relevant provisions, that is 33C 1A and 33C 2A
yes.
and 2A 1A and this thing whatever 2A have not been considered.
Not been considered.
Correct?
Yes.
Next.
Therefore, to say that the principle of stare decisis
doesn't
applies in this case has no application to the facts of this case. But the other point which I wanted to make was with regard to the issue of government officials transfer, because much has been stated by the state.
No, some other two submissions you just told us before we were rising. Some two submissions you made, which please say, we are noting down everything. What you said something, two more propositions.
With regard to government officials, the state had said, Melons, that this government officials being transferred to another's
15%. They will come.
Page 24.
Your case was that they have to compete under 15% quota was the submission of Mr. Prabhakar Rao.
Yes.
That you said would not apply. Now it will apply
because the illustration and that clause which has been referred to by the state at page 24, your lordships may see, which is
their vacate petition.
In the vacate, I'm sorry.
Illustration and clauses.
Of GOP 646 dated 10/7/79.
Where is which page?
Page 24.
24 of the petition or vacate petition?
Of the vacate, I'm sorry. Of the vacate filed by the university.
That is para number 10.
Yes, para 11. Yes, ma'am.
Page 24, Mr.
Yes, ma'am. Page 20.
Page 20.
Page 20.
Yes.
Well, it begins at page 21. Well, it's page 24. The lordship had to see para 11 and the illustration which the state sought to rely upon at clause 3. That Roman
is 15% of available seats.
Shall I read it, madam?
Yes.
Yes. As clarifications were being sought on the question as to who should be considered eligible to apply as candidates belonging to the state of AP for the purpose of admission to courses studied course studies offered by educational institution subject to the control of the state government against 15% of available seats kept unreserved in terms of AP educational institutions order of 7. Government, after careful consideration, has directed that the following categories of candidates may be treated as eligible to apply for admissions to educational institutions in the state subject to the control of the state government as candidates belonging to the state of AP against the 15% of the available seats left unreserved in terms of the residential order. Now, fellas, there is an illustration to explain this proposition. All local candidates defined in the presidential order, candidates who have resided for a total period of 10 years excluding this is not. The third one is what they have relied upon to say that the case of all India services or central government employees falls in that. Please see, candidates who are children of parents who are in the employment of the state or the central government. Lordship may see, candidates who are children of parents who are in the employment of the state or central government, public sector corporations, university, employment of the children of parents who are in the employment of the state or central government. This primarily, therefore, if your lordship were to stress on this sentence. When they use the word employment of this state or central government, it means a person who belongs to Telangana cadre. He may be from UP, for example, madam. He may have come into Telangana cadre. Therefore, he is in the employment of the state or central government. It is with regard to such persons who are transferred again from this state to another state. What happens to the children of such persons? Supposing they stay here for a long length of time. But
No, but you are not claiming 15% unreserved quota.
To say is
Considering all the petitions fall under class 11.
No. What I'm trying to submit is the clause and the illustration which has been shown by my learned friend to be applicable to us as central government
Doesn't apply.
doesn't apply because we have not stated.
So, Mr. Rao, you are conceding that they are entitled. They are saying we are not entitled under clause 11.
My purpose in the reply was to show that we are
No, Mr. Why not take this benefit by way of an alternative submission that if we don't succeed there, at least his concession may be recorded and this benefit of clause 11 be given to us.
Yes.
That is a better argument.
Yes, but clause 11.
Instead of saying that we don't fall.
Yes. Oh, I see, my lords. 85 is not there, then.
If 85 is not there, alternative submission is please consider it eligible because Mr. Rao is so magnanimous.
Yes, if I may say, a very miserly concession. Because it is only 10%.
In your absence, we asked to explore the possibility of this also.
I see.
Whether he would, but he did not say anything. He wants us to adjudicate. Fine.
So what I'm trying to submit.
Alternative submission we have got. Alternative submission is that be considered eligible under para 11.
Yes. In this case,
Right.
as in the case in which he is appearing or I am appearing, my lords, these persons are not people belonging to Telangana cadre. They are natives of Telangana. They got employment here. They were transferred from another state. And therefore, their children would fall within the 85%. And
Your client was born in a hospital of which we know the name.
I see.
In Hyderabad, right? You have been so transparent enough to say that which hospital.
In item 40. Yes.
That's it, Mr.
Sometimes when we speak of this
No. It's see, Mr. Reddy. Always, we say some things in the lighter way. All the time, atmosphere of the court can't be like serious, right?
Yes.
Where we have to be but at times we require a little break also, no?
like a classroom, maybe.
Huh?
Sometimes.
Yes, little this thing. So that's why don't then not this thing. Anything against you or anybody, just. So you not say, we remember when you argued he was born in this hospital in Hyderabad, your petitioner only. Fine.
If I may compliment this bench for remembering that fact.
No. So this proves the point that once you speak, we hear with rapt attention, 100%. Yes. So that's it.
So therefore, so this point is important, my lords, because it seeks to oust the claim which is being made by the petitioners to fall under 85% by simply placing them under this 15% bracket.
So alternative submission, we will record that in case the petitioners fail in their main submissions, they should be considered eligible under clause 11.
Yes.
As considered by Mr. Prabhakar Rao.
Yes.
Correct?
Yes. That is important.
Yes.
Because we don't belong to state cadre at all. And
So first we examine your initial contention that first we examine validity. Then we go down whether if supposing if you fail in validity, then we go down under whether which clause you because you say that I am covered by this clause, majority of the period clause, that we decide.
Yes,
Even if you lose out on that, then you come back to clause 11,
yes,
correct?
clause 11, for that, those limited cases.
Yes.
Well,
We don't know. I mean, we are just telling you
yes, yes.
the sequence, right?
Hello.
Yes.
And if I may submit, like tax statutes, my lord, what I'm trying to submit is these statutes, my lords, if I may submit what I've understood by reading this is not in the form of adversarial litigation. Ultimately, my lords, it is to benefit a very valuable constituency of our nation, which are the students, and to promote a public policy aspect which the state wishes to do, that is reservation for local candidates. If the manner in which the state is proposing to your lordship, that interpretation were to be taken, then the predicament which the full bench found in its last para, they say our interpretation may mean a person who comes from another far off state and does long-term coaching in this state becomes a local candidate. But for some reasons, certain people who are natives of this our state but go to another state for some reason become non-locals. But what are we to do? We are bound by the presidential order is what the full bench says at page 57. But my respectful submission is, if my lords were to see those clauses which perhaps...
See, full bench, you just now you have argued as no precedential value.
Presidential value. But what the state is proposing before your lordship, the interpretation and what they are trying to place before your lordship, will lead to that most unenviable situation. And that does not promote the interests of the state nor the protection which this 85% reservation wishes to bring about. It's a danger. It's, if I may submit, I wouldn't say dangerous, but my lords, it's a proposition which helps no one. It's a proposition which helps absolutely no one. And for the honorable courts, because your lordship under 226 are also a court of equity, not merely of law. And if I may submit, 226 much wider in scope than 32.
Yes, yes, of course. Supreme Court itself has said.
Because my lord,
see, we all know, you also know, no need to, it's wider.
Wider. So if that proposition and for the protection of the interests of the students is seen, my lord, then the predicament which full bench is saying we can't do anything this like may not detain this honorable court, because your lordships have seen those relevant clauses.
No, once we agree with your submission that it does not apply,
yes,
nothing. Right?
Yes. Therefore, my submission is the mechanical application of full bench, my lords, with great respect, as has been done in a previous order of this honorable court, that is WP 38580 of 22. The relevant page is at page 66 of the vacate papers.
It should not be mechanically applied.
Yes.
The ratio, if any, even assuming,
yes,
this is again an alternative submission, that in case this court holds that the full bench applies, then also
yes,
the ratio laid down therein should not be mechanically applied.
That was why, my lords, we faced
which has been done by a division bench of this court.
That's why the stress was laid on para 45. Was to show that para 45 of the full bench only referred to residence alone, not with regard to study. We are concerned with that length, that 7 years period, the larger period of study is what is relevant. That has not fallen for consideration before the full bench, and therefore before the division bench also, that was not canvassed. The division bench simply said, this court at page 66, if your lordship were to see, as the division bench's order, our division bench's order. I may just read out the relevant.
We have seen that it only refers to full bench, and
he is not entitled for any.
That's why you have used mechanically.
And the same thing, with great respect, is what the Honorable AP High Court has also done, my lord. There is no specific holding which emanates from the AP High Court's, Honorable AP High Court's decision, which is at page 68 to 86, which is WP 10319 of 2019, wherein at page 84, which is the operative portion of that order, lordship may see page 84 for a moment. There also they have examined the full bench order
And I've said if for a period of 7 years, if you have not resided in this state, since full bench have said you are not a local, we are constrained to hold that you are not a local. This may not, these two orders, stare decisis, will not apply because these fact situations which are being sought to be brought out now was never there before.
Got it. Yes. Anything else?
No. This is
Thank
all.
you. Thank you, Mr. Thank you. We don't think anything else. Anything else now? He has argued so well. Put out his points with clarity. If you have anything to add, then please add. Otherwise, you can.
Covered by people.
Like first round, he adopted. This round, you feel inspired from him and follow. You have heard him. He has presented it in a very crisp manner and this thing.
I always follow him, but I took inspiration.
But the other side, Trump party, main contention, presidential order and full bench.
So so he has said, he has told, no, Mr. Mayur Reddy has told us that this validity of presidential order has not been adjudicated by Supreme Court. Then again, you heard him, right? That that the rules are made under the act. Act is also not under presidential order. It is in exercise of entry 25 of third list to 7th schedule.
List 3.
So therefore, independently we can examine. So no. So therefore, we can examine the validity of the rules. Then principle of another, your this thing, reading down Bombay Division Bench of Bombay High Court, saying that principle of reading down has to be applied.
Whatever he has not said, I said.
1 minute then. If you want to argue, we will give you time. But let us see. For our facility, memory, we will write his submissions. Then you argue whatever. Yes. You rejoined the learned senior counsel, Mr. Obliged. Now we see what he does. Your submissions are intact before we get confused, so we reduced it in writing.
I'm sure he'll only elaborate and
There is a-
clarify.
But the other side, main contention is a presidential order and followed by full bench. Two contention. If I convince your lordship that the presidential order has no application, and inter alia full bench has also no application.
Now we see what he does.
My submission is,
Your submissions are
President has
intact
not
before
issued-
we
your
get confused, so we reduced it in writing.
I'm sure he'll only elaborate and clarify.
Submission, you know
the other
that
side,
we are,
main contention
when you
is
began
for
the
a
argument,
presidential
we
order.
requested you to give
And
your
followed by full
proposition,
bench.
just to elaborate. First proposition.
Two contentions. If I convince your lordship that the presidential order has no application. I will say, inter alia full bench has also no application.
Now we see what he does. To Mr. Reddy also, for sake your submissions are intact. Before we get confused, so we reduced it in writing.
I'm sure he'll only elaborate and clarify.
You know that we
A presidential notification regulating the admissions in educational institutions. After 2/6/2014,
regulating admission
in a state controlled education, the educational institutions.
in educational institutions.
In the two states, in successor states.
In any case, in for state of Telangana, we are concerned.
They may interpret the 1874, 74
Was either the state of Telangana
Andhra Pradesh. Because I dealt with the matter as an advocate general.
That's why.
And 2014 to 2017.
No, we were told that one of the GOs was issued when you were advocate general.
I've settled one. I've gone through it and I've settled one.
No, that's what my brother shared with me, that the one of the GOs to which you are referring was issued when you were advocate general of the state.
All the GOs, but the first 3 years my work is only that.
So first submission, this is second one.
The second one, the first submission, there is no presidential order.
Okay, second.
The second submission, well, the presidential order issued in the 1974, 50 years back.
It does not apply. That you told, does not apply after 2/6/2014.
If a president issues any notification, pardon, it is only state controlled institutions. If a president issues any presidential order, in terms of Article 371D, the president is only competent to issue in respect of state controlled institutions.
No, that is may not be necessary for us to determine what is the
present rules.
Mr. This like this can't go on right now. Mr. Rao will not argue. He has concluded. You are replying to his submissions. Don't make out a new case. Then we will have to give. He has not argued that president has power to issue in respect of all institutions.
The present rules were issued is not only state controlled institutions and private institutions. I will.
Mr. Rao.
But then my lordship tells 371 email. One.
Mr. Senior, Mr. Prabhakar Rao, in arguing, he did not put it on that ground.
I'm only glad to say.
No, what we are requesting, Mr. Reddy, is that your scope is only confined to meeting the submissions of Mr. Rao. Don't start re-arguing the case, then again it will never end. Then he has to be given an opportunity, then you will rejoin the. He has put it very briefly, you have heard him saying.
I'm trying to within 10 minutes. I will not go into it. But I wanted to convince you the presidential order, no application to that I'm saying. So these are my points, but I will finish.
These are the 2 points, right? 3, we will not go into it. We are telling you at the instance, we will record it, but we will not go into it because This is not what is argued by Mr. Rao. Correct, Mr. Rao? You did not argue that presidential order can be issued in respect of all other universities other than state-owned institution. You did not say, right?
Section 95.
You only argued that it is, these rules are in perimeteria with presidential order. And therefore,
Section 95 of the Reorganization Act will govern this.
Yes, sir, that's what I'm coming right. It's about section 95 of the Reorganization Act.
you read it.
Alright. Section 95.
What? Section 95, Madam, Reorganization Act.
Before taking down section 95, I request for 371D of the Constitution. 371.
Constitution. That validity of 371D has already been upheld by Supreme Court and nobody is challenging here in the petition. You are not challenged.
Two Roman 3. 2 Roman 3. 371D. Then I request you, your also kindly see the parent. 397 and is report 95.
So you are not seeking admission to state-owned institutions.
Why the present?
No, we are asking like a query. You are not seeking admission against any state-owned institution.
What we are seeking?
Okay. Oh.
You're also 95, section 95.
Yes.
Section 95 of reorganization. Equal opportunities.
Oh, 1 minute. Yes. 95.
95. Equal opportunities for quality of higher education to all students. In order to ensure equal opportunity for quality of higher education to all students of successor state, existing admission quotas, but only quotas. What is the quota? 70. In government or private and aided or unaided institutions of higher technical and medical education. Liberal protection has been granted in section 90. Not only government institutions, all private and other educational institutions. The president can only issue in governmental institutions. So therefore, our rules you also can say, coming to our rules, 114, now the issue. Thank you. Thank you. One. Page 18. Oh, my petition. My first petition.
Yes, yes. Yes, yes, we have got.
You have also kindly said, proposal submitted by so and so. Non-minority medical colleges, private non-minority medical colleges, private minority medical college, and private non-minority dental college. These rules not only government and private college. So, my lord, this GO is in accordance with section 95 of the Reorganization Act. And on the face of it expressly, the GO was not issued under Article 371D of the Presidential Order.
That he has told.
The Presidential Order. Presidential. Not issued under Presidential Order. Therefore, what are the quotas? The quotas. 97, 95 contemplates protection of quota. Quotas is your absolute. The government paper quotas. But the government papers, the university papers.
Which page?
Take it. The control order, they pay 15 minutes. Page 19, section 6, page 19. Page 19, paragraph 6. Section 6, it is not proper. Presidential order, say paragraph 6. So, admission to the 85% of available seats in every post study by statewide university or statewide education institution shall be reserved in favor of local candidate allocated among the local candidates in relation to the local specified in subparagraph 1 of subparagraph 2 of subparagraph 3 of paragraph 3, the ratio that is these are quotas. 42 Telangana, 36 Andhra, 22 Rajasthan.
Just now, Mr. Reddy has argued, Mr. Mayur Reddy has argued that this, which you have also said, that the rules have been issued, impugned rules have been issued under the Act. Act is enacted under entry 25 of list 3. It has nothing to do with the presidential order. On one hand, you are arguing this that presidential order has nothing to do with the facts of the case, and you are relying on section para 6 of the presidential order. This can go together, we were wondering.
I'm saying in 95, these quotas only. And what I'm submitting, the presidential order is not protected. The Reorganization Act 95 has not protected the presidential order. Only quotas specified in the presidential order. The president, the state,
That's all right. Section 95, this you do.
has only protected the quotas described in the existing quotas of the
Described in presidential order.
The presidential
universities which were existing as a, in fact, we wanted that.
This, what is submission is that section 95 only protects the quota prescribed in para 6 of the presidential order. And applies only to universities which are there. Applies to existing universities. Universities existing on 2/6. That we have already agreed that the other day we allowed them to declare it. So only that was the condition.
But what I am submitting, right, the section 95 did not say. But the man, but section 95 did not say.
Mr. Only thing is, Mr. Senior Counsel, it's always a pleasure to hear, but this is, scope is confined. To what? This is not a fresh argument, right? You are arguing for fresh.
Giving reply, nothing says the presidential order will apply. Presidential order will not apply, only quotas are protected.
That's what you are. That, what else?
So, but this aspect was also dealt by the full bench. But your lordship, the full bench. And intervene at the same time, a 646 GO was issued under para 6 of the presidential act. Paragraph 8, paragraph 8. Paragraph 8. Paragraph. That is only not applicable. Paragraph 8 of the presidential act.
Geo 646. This is 21 of what? Vacate petition. Vacate. Issue.
Therefore, 646 also no application. When presidential order is entire presidential order is no application except protection of quota. That was dealt with for your assist. It will be required. Will be.
If we hold that the reference need not be made to presidential order, are we required to go into this issue? If we hold, we have to come to a conclusion. We are only suggesting. If we say that GO 114, we accept your contention is not issued under presidential order, then are we required to examine this aspect? No, that is true. But you see, but we are not. But what I am saying is, if we are with you, assuming we are with you, we are not with Mr. Rao on that aspect, that this GO 114 is not issued in terms of presidential order. Therefore, the reliance placed by them on presidential order is not correct. Are we still required to go into this issue? No, that is true. But that's why I'm saying if we are. We have understood, that is why the full bench also places reliance on Article 371, the And therefore, we have examined that Mr. Mayur has already elaborately dealt with it. Both the issues we have considered. If any further new point, like you said, the GO, the 646 is under clause 8, we have noted.
For my submission, there is no preference. There is the full bench has relied upon, considered by the full bench, laid out the law. There are not full bench of obligations.
That we have noted. Not only the full bench, the subsequent two decisions, one of this court and one of the AP High Court have also no relevance. That we have noted, yes.
Then once the last time consider the rules, under the rule, the inaction is the same.
Yes, yes, principle of reading down has to be applied.
The inaction.
You have already argued that. You need not repeat. You are relying on Meenakshi and then Bombay High Court. And you are saying that it has to be read down in context of children whose parents are members of All India. We remember, Mr. Your submission, not that forgotten.
State government rule, the rule says that. If somebody by candidate comes to para over 1, the 2 years they exempted, alternatively paras. 7 years. That by
It is like putting the cart before the horse or horse before the cat.
You are not sure that we have understood or not. So therefore this lighter side, Mr. At least you can smile, right? There's nothing serious. Same thing you just now you said.
That's why I said if it had come, that would have saved the
time.
Trouble of writing down.
You have got it, Mr. Rao. Yeah, give it to him first before passing it on. Simultaneously, correct. Yeah.
This is nice.
Thank
I'm
you.
very grateful.
Thank you.
Grateful.
Right.
Kindly pardon me for taking leave of this honorable court. My friend is saying the presidential order has no application, GO 646 has no application, and also the full bench has no application. Last may kindly see the rules, rule 3 will adjust. For my benefit adjust. But it is not under challenge. Well, the eligibility criteria.
They are required to satisfy under order.
But this is not under challenge. That's no limit.
Which page?
Rule 3, page 9. Page 19 of my senior counsel's book.
19. This.
Eligibility.
3A. 3A is not under.
Local, non-local status. Requirement has laid down to the President, the Andhra Pradesh Education Institutions Regulation of Admission 1974 as amended GOMS
to
GOP
satisfy.
number 646.
That is with regard to quotas which the Honorable Senior has placed before your Lord.
All right.
Further,
The power is at the beginning.
That's it, Mr. Rao.
Further, my lord, the facts in full bench. Also, my lord, a candidate has studied in Guntur first to 10th class, 2 years in Gujarat.
You read it?
Same thing is the all the candidates, same thing. They did not study 7 years of education.
But this is a different, right? Here is a candidate who studied up to 10th in Hyderabad and attended online in Kota. That is not covered by full bench. Because full bench when it dealt with lighter side, Mr.
That is also.
Online classes were not contemplated when 2001 judgment was delivered by full bench.
When that case comes, I will make my submission.
No, everything comes and goes. It's closed now.
But my submission was on that case, my submission is.
No, all these cases are being closed, Mr. For now, reserved for delivery of judgment.
I filed my counter in that case. In that case, the study study 5 years.
That we have understood. We have understood that petitioner in that case is not entitled, even though she may have resided, but she was studying in an institution recognized by you.
That's all. That's all.
That so far we have reason to believe that our memory is good so at this point of time in life also.
The senior counsels are powerful in arguing the matter, therefore I just submitted my name.
All right.
Yeah. He may be senior by designation. They are the mighty state. One individual against.
I know, we don't know whether, but Mr. Rao is also mighty person.
The state under 12.
State under 12. Yes. Yes, please. Thank you, Mr. Reddy. It was pleasure. Yes, Mr. Reddy, pleasure hearing all of you. Yes. Mark everybody's presence. Reserved for delivery of 1 minute. Reserved for delivery of judgment. Which cases? These cases of number we have taken, right? So what item number? One minute, madam. No.
Other batch.
Batch. What are you? 41 to
39.
41 to 50.
39.
50.
They are 41 to 52, my lord. 53 to 56 is another matter.
No. We are reserving only 41 to 50.
Very well.
Huh?
Milord, I am in 51.
51 is different.
Submissions, not in
51 and
51. I am in 51, Milord.
51 is that.
Online, Rajasthan quota, Milord.
That he has told, no.
Milord, I have to make my submissions, Milord. That is the reason
Make submission differently. We will not hear you now. This is, madam,
Milord,
proven to the court. Being not reasonable, just a minute, not being reasonable to the court when these people are arguing.
Milord, I am waiting.
Just a minute. You don't be there and then say that my case is different.
I am there, Milord. I am only waiting for my turn, Milord. I was.
This is, Mr. Rao has argued, right? Just
Yes, Milord. I have to make my reply, Milord, to his argument.
all right, we will exclude your case. Sit down.
Yes.
First, sit down.
51.
Sit down, please. Nothing is being done in your case. It will be called. Please sit down. Item 41 to 50. Arguments heard reserved for delivery of judgment. What are 52 you are saying, Mr.?
My lord, 53 to 56, my lord.
No, different. That is NCC quota, Mr.
Yes. That's what I.
52 is what?
That means a cap.
Cap. The cap is also different.
Cap is different.
He has got special instructions in that case, Mr. Rao. 50. Rejoinder, reserved for delivery of judgment. Then in that separate page, right? Learn it. Learn it, senior counsel. For our memory, we are what Mr. Reddy, senior counsel, has argued.
Just
Sit down, sit down. This is reserved. Learn it, senior counsel for
petitioners who are before the court, everybody else results are declared. Petitioners may also be declared. It appears as if we are being punished for being in court.
We have considered, we have kept it whole as ordered by the Supreme.
But everybody else.
Result declared?
No. For these candidates.
No, generally declared.
Declared.
Declared. So
We should also be declared. Why we are being withheld?
But your lordship, that.
The 15%, considering that the 15%.
at least consider against 15% quota.
Consider lordship.
No, but you have withheld their results.
We have withheld.
Lordship, may pleased to say, your lordship's order to consider their cases, we considered, kept them in hold.
Sealed cover. If Mr. Rao alone knows what is your fate. This file, we don't know.
No, if no result was declared, we would have no case. But if results are declared, why?
That's what we are asking. That's Mr. Rao. You had considered para 11 of this thing.
Yes. We'll consider that.
Consider it.
Yes.
So,
Para 11, they will consider if you are eligible.
para 11 is only for 15.
15%.
For people. But for the
And rest is
Yes.
subjudice.
Yes. So
That's the difficulty.
Yes.
That's why we are doing all this exercise, right?
Yes.
For our memory, we are writing here so that we may not miss
Yes.
everything, updating ourselves with each passing moment.
Very good.
So we'll try to do it as fast as possible.
Yes. Deeply obliged.
But Mr. 15% quota you will consider, right? 15% quota as per para 11 you will consider petitioners.
Sir, consider the case of my senior, my counsel, my lord. She got the seat under 15%. The Rajasthan case.
Then end of the matter.
Petitioner is entitled.
No, 1 minute. We first here, she wants to argue the case. You are not interested in seat argument. So 1 minute, madam. 1 minute. Your colleague is unable to point out that her case is entirely different and under cap quota. So we want to deal with her first.
Yes.
1 minute. We will take up your case. Still,
I'll wait.
still 25, 30, 35 minutes. We will sit. What is 52? What is cap? This is different. Cap quota is what?
Cap quota, my lord. The petitioner in a
1 minute, Mr. Rao, lighter side. So you have declared you have said that item number petitioner in serial number 51 has qualified. So, and you have not said anything about others. So inference is that others have not qualified. This is lighter side. Inference we can draw, and the Mr. Reddy must have drawn is that other petitioners are not qualified under 15% quota, even though you would let them know at a later point of time. Okay. We don't know. You may be in for a surprise also. No, Mr. Rao, should you not inform us? So in that case, those petitions can be disposed of by us. All other candidates may not be interested in arguing like Madam 51. They will, if you get in 15% quota, what?
Yes, madam. Out of the two matters I've argued, one is under that concession. Because there's some government.
So, at least those cases we can.
This honorable court direction was to treat them as local and consider. Now we will consider, my lord, in the para 11. Just now I will report to your lordships.
You can tell us now. Yes, please.
Para 11.
End of the day.
Para 11 peculiar to government.
Yes. So he will tell us. You should wait then. Don't leave the court hall. Sit here and be a part of audience.
In that case, even in the affidavit and also the additional affidavit, there is no the averment that she made
Told her yesterday, but she
made an application.
here, didn't do anything.
She made an application on cap category for persons who
What
apply.
happened? She has passed which the
Lordship may kindly see.
1 minute, madam.
The person who seeks to claim under cap.
Until unless you understand his objection, what will you appreciate? We have told you yesterday, day before yesterday also that amend your petition. You didn't do so.
I have done, my lord.
Blood under rule says.
What happened? She appeared in this thing, NEET, UG examination. Then what happened?
She qualified in the NEET.
Qualified. Then
Blood she claims blood. She claims admission under cap category. There is a 1% of seats are reserved on cap category. For to person eligible to be considered a cap category need to submit Milord the residency certificate of her father. The petitioner did not Milord the enclosed residency certificate.
So when she was required to submit, when she applied?
When the application for online applications are invited, she required to submit Milord the residency certificates of her parents, mother.
Did not submit along with application.
Yes, Lord.
Then
now the writ petition is filed seeking direction to the university to receive Milord the residency certificate of her
you
father.
receive, Mr. and consider in second round of counseling because why? One minute.
That's why no counseling is conducted for cap category. Cap category is the separate counseling will be conducted.
When?
Milord after second phase or Milord before the second phase.
So in the counseling for
the cap category has not been considered. Well,
not held, therefore you will consider?
I will consider, Milord, subject to your Lordship's direction.
We will direct.
Milord, then Lordship may kindly see that the Sainik Welfare Department will consider your application and also the under the rules, Milord, the application will be referred to the Sainik Welfare Board.
1 minute. She has got the residence certificate now.
She says, Milord, that she got
43.
Milord,
Page 43.
issued by the
whether she falls, Milord, as a residency or whether she falls, Milord, under cap category or not.
That will be therefore you will
examine very
consider.
Sainik
At this point of
subject
time,
to your Lordship's
grievances
direction.
permit her. We will direct. So will you
Then Lordship may
permit
kindly
her
see
or we should
that the
issue a direction?
Lordship may give a direction to receive, but it's the exception, Lord. Tomorrow, number of cases will be filed.
No, what's
Because
the problem? Why she is ineligible to participate in the counseling for
Because she did not enclose. Yeah, she did not enclose residency certificate.
Mr. Rao, what was the last date when she applied?
28th was the last date for submission of the residency certificate.
Madam, 28
July.
12 dates
No,
in
sorry.
the year.
28th July 2023 was the last date, Milord.
Very certain things are very clear to your
Sorry,
mind. We
Mr.
don't know. 28 July again 23.
23 was the last date for submission. Milord, the petitioner could not get the residency certificate issued by the MRO by that time. So she requested through an email, requesting the respondent authorities
No, so
to
they are
grant the
not
fine.
responsible, right?
No. She requested, Milord. Thereafter, 29th was the last date for the submission, Milord.
Government has to issue through message. Issued on the 31 7. Tahsildar will actually this rated.
Tahsildar. Issued on 31
7 2023.
and she applied when?
When did you apply for this certificate?
Applied on the
See, if there is a delay in the government agency issuing, we can understand. You are not at fault. If you have not applied, then how can we consider?
Milord, I have applied on 28th 7 only, Milord.
Same day.
I have applied on 28th 7. That they, even before that, actually, the petitioner's brother, he went because the petitioner was staying in Jammu and Kashmir. The petitioner went to the MRO office to get the residency certificate of the petitioner.
Why should have made it not take these people argue at the top of their lungs and something that is being the way I'm sure I would trust if it's about right interim order.
So who is at fault, madam?
Milord,
You argued like that day we were rising
Milord,
and 1908 you argued at the top of your voice that injustice is being
Milord,
done.
Milord, kindly refer
At
to the
28
5 of the affidavit, Milord.
28 July was the last date. You applied on last day, got it 31st July.
Milord, kindly refer to the para 5 of the affidavit, Milord. Writ petition.
Mr. Rao, you consider, Mr. Rao, consider are in the round of, we are passing an order, not on your this, right?
As a special case, let me say, tomorrow Milord, it forms a precedent for a number of cases.
There's no other number and she won't file any other case.
See, Milord.
Huh?
I'm not fighting any case.
Don't invite that I'm getting an order today evening, come tomorrow, we will file another petition.
No, Milord, not,
Will be dismissed with costs.
not under the cap category.
So madam, never this thing, you are arguing as if some statutory right is being infracted without realizing the position under the rules that the counseling is separate round of counseling is held for cap category which is yet to be held. And you are not prepared to wait even on that Saturday. You are arguing from 4:45 and you made us write 1 page, 2 page order. This is all unreasonable to the court.
I'm sorry, Milord.
This is the order which you have argued at the top of your voice and we have to pass an order saying that no, this thing counseling is being held. Yes. Mark the presence. With consent of the parties, the matter is heard finally. In this writ petition, the petitioner inter alia seeks a direction to respondents to accept the residence certificate dated 31 residence certificate of the petitioner dated 31/7/2023 and to treat her as a candidate under the cap quota. What are children for armed personnel quota for admission to NEET PG, NEET UG course, NEET UG course, paragraph. Facts giving rise to filing of this writ petition briefly stated are that
7. Milord, is page 31, Milord, our application.
Acha. Yes, madam. Last date 18/7 you have written, you alter it to 14/7. Previous paragraph 18/7.
Date for applying portal is 28/7. Portal
Last
28/7 only, no, Mr. Pravakar. For registering, it is not up. Registering with the university is 28/7. But along with the registration, they need to upload the certificate.
Yes, sir.
Because she did not get it, though she applied.
No, that's the case, but he is saying 14/7.
She made application 14/7.
She made application to the.
Page 31, last please.
Last date was 28/7.
Milord, it is subject to correction, Milord. It is 29/7 at 4 p.m.
29.
Kindly refer to the
See, Mr. Rao.
line number 5 of my writ appeal. In the interim, she made the university on the
Writ appeal, there is no writ appeal, it's a writ petition.
petition. In the interim, she mailed it to the university on 28th July
30.
before the cutoff date and
Huh?
of the 4 p.m. on 29th July.
He is referring to data.
Page number 13. Milord. With the request to allow time till 1st August 2023.
Page 40.
The cutoff date in time was 29th July 2023 at 4 p.m. Because 29th was
May kindly see page 46, Milord. My friend is
Yeah,
not
whatever.
correct saying page 46.
All right, so we will not go into this. There's nothing.
Starts from 7/7, Milord, ends
Nothing there.
7.
It's a peculiar, not a precedent. What considered submission, peruse the record. Admittedly, the petitioner had submitted an application seeking admission to MBBS course under cap quota before the cutoff date. However, the petitioner could not submit the residence certificate on or before last date of submission of such an application, that is
14/7.
that is 14/7/2023, as the did not submit so and so, full stop. The petitioner, on account of circumstances beyond her control, was away from Hyderabad and could submit an application only on her return to Hyderabad on 28/7/2023. Thereupon, the Tehsildar has issued her residence certificate on 21/7
31/7.
or 28/7. Sit down, madam. 28/7/2023. 28/7/2023. Full stop. The entitlement of the petitioner for consideration under the cap quota is under cap category is not in dispute, right? Whole thing is not in dispute, right? The counseling is scheduled to is yet to take place. Is counseling for admission to MBBS course under cap category has yet to has yet to take place, is
Yet to be notified.
yet to be notified. Therefore, in the peculiar facts of the case, we permit the petitioner peculiar facts of the case, taking into account the fact peculiar facts of the case, comma, the petitioner is permitted to, the respondents are directed to permit the petitioner to furnish her residency certificate. Needless, residency certificate of her father. The aforesaid, the respondent shall consider her candidature, petitioner's candidature under the cap code category. We hasten to add that this order shall not be treated as precedent, as the same has been passed in the peculiar facts of the case. Paragraph with the aforesaid directions, the petition stands disposed of, certified for. Madam, in the previous paragraphs you have read last date, etc. You write 14/7 there. 28/7 wherever you have written, you write 14/7. Petitioner applied on 14/7. That paragraph is correct, right? Last date 14/7. Disposed of. This is 52, right?
52 is
No, this 51.
Item 51, Gopal. May I please?
What, Mr. Rao, you wanted to say in this case?
Lord, I have
1 minute. Huh? Sit down, Mr. Yes, Mr. Rao.
Regulations, my lord.
No. So you said that she has qualified?
She has qualified, my lord, in unreserved category. Unreserved category, she was given admission in Mallareddy College.
It survives for admission to Hyderabad.
Second competency being to so she bring
Not satisfied.
faculty. Not only fees common, if they get under related it's common. Regulation, but the thing is that
There's some other college in not in Hyderabad.
little away, but that is
so-
the major issue.
Yes. So her grievance survives, right? She doesn't want to, she wants admission only in Gandhi Medical College, Hyderabad. So therefore, survives if otherwise if it is dismissed, then she takes admission wherever, right? But
Well, also pleased to direct in 3 cases.
One
treating them as a local candidate. University was directed to consider their cases. But on treating them as a local candidates, 3 candidates have got admission in various colleges. But below in the presence, for 15% quota, they may get
yeah, no, Mr. Rao, in her case, 1908, there was a direction to treat her as local candidate.
Yes.
So have you treated her local
candidate? She was treated as a local candidate. Her admission was given, but it was withheld.
Withheld? Admission, she is entitled to admission, which where?
But in Karimnagar College, she got admission, but
which college?
Karimnagar.
Chalimedam Anandarao Medical College. But the allotment was not given.
So if the petition succeeds, she will have to go to Karimnagar.
Yes, sir.
Yes, madam.
One submission. Just may pass on without the.
1 minute, we are just going through the long order which we have passed, so we refresh our memory. So, Mr. This thing Rao, in this case, since we have heard you at length in the previous bunch, your submission is, even though the petitioner was residing in the local area, but she has taken admission in a
recognized
institution, therefore under that regulation she is not entitled.
She is not.
This thing. Which regulation not entitled?
4-1. The
4-1. No, not president, but this rule you referred to rule.
Yes.
Where is the rule? Which page? You must have filed the rule. The petitioner has not filed rules. You need to file. Where are the rules, madam? Which paragraph?
21268, 21268.
Her case is 218893. You have not filed rules.
I have filed the prospectus, my lord, in that regulations are given, my lord. Same one, I am relying on the regulation. I have filed the prospectus, I have not filed the rules. 114 I have not filed, my lord.
114 is there at page 68, madam.
Ah, 68, no, yes, 68. The order.
Lordship may kindly see, my lord, another repetition, my lord, first repetition of Manoj Reddy.
No, we will find out, but we are just trying to find out in these rules, it's not, in this, not there.
Page 18 of the thing. Manoj Reddy case, my lord, 2126, a senior counsel, my lord, Ramakrishna Reddy.
21?
But
that is there.
in that, my lord, rule small a, small b, my lord, small. Rule 3, Roman 3, capital
Rule
B.
3, Roman 3.
Capital B, small b.
She is claiming entitlement under which rule, Mr.? 342, 3.4.2 within bracket Roman 2.
The rules, my lord, it is rules, my lord, small b, capital B, rule 3, Roman 3.
Rule 3, number
Roman
3, rule 3, Roman 3, capital B.
Small b.
She is claiming entitled under this. Get that file.
I just read.
Lord, at page 68.
1 minute, madam, you don't annex the rules, what to do?
It is there,
And then-
page 68.
Where during the whole or any part of.
Madam, your paper
to
is
academic.
incomplete. Please go to page 70. I will tell you. I did not want to tell you. Now please read. There is no B at all. Please read. Page 70.
Her petition is. This is one.
Please read, madam, your page 70. Look at the page 70. Where is capital B?
One line has. And I apologize, but by taking this missed.
This is what we are saying.
May I read, Lordship?
Ah.
Where during the whole or any part of the 4 consecutive academic years, ending with academic year in which he appeared, as the case may be first appeared, for the relevant qualifying examination, he has not studied in any education institution, if he has resided in the.
We remember.
That's all.
Yes, madam. Now the only thing is you are claiming entitled under rule 3BB.
Lord, I have prepared a synopsis of that fact for please.
You are claiming, is it not correct that you are claiming under?
Yes, Lord, I am clear.
So where is that rule? Read it. His interpretation is that since you have, even though you have resided, but you are prosecuting a study course approved by government of Telangana, therefore you are not entitled. This is what has been argued.
Yes,
What is your submission?
Lord, first my submission is, Lord.
Hey, madam,
Petitioner
that,
has continuously resided in Hyderabad. Facts is
that they are not disputing.
Yes, my lord, they are not disputing on the facts. Now, only thing is with regard to resident in the clause, regulation or the rule. My submission is the petitioner has resided in Hyderabad on account of COVID pandemic.
He is not disputing that you have resided.
Look, I'm coming to that, my lord. And during COVID pandemic, all over the country, my lord, all students were permitted to study online, my lord, and she has pursued. And now with regard to recognition, my lord, what is being submitted is not correct, my lord. Your lordship may kindly take first presidential order, my lord, which is at page, the counter they have filed, my lord. The lordship may kindly take page.
I decided to get. That's what I'm saying. I'm looking there.
Whatever president has the reputation as school, she is prepared as. Where is where
Studying, Mr. As she was studying in a course approved by the state government.
State government.
She was studying a course approved by the state government.
Yes, sir.
So you want the students not to prosecute any course and stay in Hyderabad and enjoy. If somebody studies online, no. You will not be treated as local.
Yeah, regulation says, my lord.
Fine. No. Mr. What can we say at 5 minutes past 4 of this 4:30? Yes. Yes, madam.
For my benefit, I will just read the provision once, my lord. Your
No,
lord.
madam, the problem is that we heard the other case for past 2 days. You were not there. So we have no, that's why Mr. Rao could conclude in one sentence because he has already argued the point. We have repeated, we told you that this is the contention.
Yes.
What you have to say?
I will satisfy your lordship.
Mr. Rao, for our benefit and for our benefit, repeat your contention.
My lord, I get it, my lord. Your lordship may kindly give me.
No, if you have understood.
Yes, my lord. I have been here. I have been following the case since 2 days, my lord. I only make one submission, my lord. Recognition is concerned. It is only pertains to the first clause, my lord, not the second clause. It is not being read. Your lordship may kindly take the presidential order for a moment, my lord, which is at page 14 of the counter filed by them. If the lordship may kindly see. Your lordship, see me, my lord.
No, madam.
Relates to.
Let us understand because we granted interim order to you acting under some misconception. Because we thought that you are covered, your contention is you are covered under the rules.
Yes, my lord.
Because you are not, see, the fact is, but please listen. The fact is that you are not relying on the rule because you have not annexed that rule with the petition. So therefore, you are relying on a clause of presidential order to say that you are.
My lord, your lordship may kindly take the prospectus, my lord. If the rules are there, my lord.
No, she does not come, my lord, within the definition of local candidate.
Mr. What we thought was that her cases she is covered under rule 3(3)(b).
Yes, yes.
What? Yes, madam. Without annexing the copy of the rule, you don't know when brother has put a query to you. Then only you realize that it's not there, and you are jumping. Yes. This is not the case. We will have to examine it in detail. So, Mr. Rao, what we thought was that it's under rule 3(3)(b).
No.
But it's not under
yes.
because she has not even annexed the rule.
Yes.
Now let's see the prayer clause. What happens is we rely on counsels when they argue. We should not.
But she did not challenge any rule, my lord.
Not challenge.
That was my case also.
And rule also not annexed. So she is not relying on this rule 3. So what's your case, madam?
May I make one small submission?
Please.
The rules are in the prospectus. They form part of the prospectus, my lord. On the other day when I made my submissions, my lord, I have read through the rules which are in the prospectus. The prospectus is at page, your lordship may kindly take it, my lord. The prospectus starts from page 33, my lord. The rules form part of this prospectus.
Madam, these rules you have
Yes,
annexed at page 68.
Those rules are given in the prospectus, the same rules.
Correct,
Yes.
Mr. Rao. 1 minute.
Prospectus, your lordship may kindly come to
1 minute. Mr. Rao, is it correct? 38.
Starts at 34.
No.
locally.
It starts at.
No, this is
In respect of what you know.
Eligibility, page 36.
condition for domicile. This is the conditions of prospectus.
No, it's not in the prospectus. The prospectus.
So then what is the difference between rule and the single?
Has to be 0, 117. So every year when they issue prospectus, they incorporate the same conditions. Instead of saying they refer to the rule in the prospectus. And same thing they have incorporated the draft to others. Okay. What they can say. But the no even the prospectus law, not challenging.
Not challenging the rule, not relying on the rule.
Because we can eligibility is only professional to read from it. No. Not. Because this refers to that's
An application for the claiming benefit of rule 3 this thing. Not what will apply then?
prospectus will not have any legal say.
Will any and shall value the petition and any benefit of it.
1 second, madam. You need to amend your prayer, which is on. For the reason, please go to the same prospectus. Prospectus do not have any legal sanctity. Please go to page 36 and see the GO there, 114. So you will have to amend your 3.4.2 is nothing but same as clause 3.333B, capital B.
Yes, ma'am.
Correct?
Yes, ma'am.
So the challenge, if at all anything, should be to that. Because you are, if you see page 36, admission shall be in accordance with GO 114.
Yes.
Correct?
Yes.
So maybe they have reproduced the same thing in clause 3.4.2 or 3.4.1.
Yes.
But the authority flows from GO 114.
Yes.
You will have to say that I am eligible in terms of GO 114. You will have to amend the prayer.
I'll make the amendment. I have mentioned in the prayer, as per the regulations, I am entitled to be considered under.
True, but if they are seeking to deny that regulation is coming from GO 114.
Yes. I'll make the amendment, madam.
Please do it.
Yes, Patel. Learned counsel for the petitioner, after arguing the matter to some extent, submits that petitioner is entitled to be treated as local candidate in view of rule 3, number 3 within bracket Roman capital 3 within bracket B, capital B within bracket small b of what rules of Telangana? What rules?
114.
Rules, right? So and so rules. Just now it has been that other aspect. Which rules, Mr. Telangana?
Telangana, just read that.
Yeah.
Telangana medical and
Telangana Medical and Dental College as
College
admission.
admission within bracket admission into MBBS and BDS courses bracket close rules 2017. Mr. Prabhakar Rao, learned Mr. Standing Counsel for respondent, submit that even though the petitioner has resided in the local area for a continuous period of 7 academic years before the immediately before the immediately before the date of qualifying examination, give the rules. What is the expression? Yet she is not entitled to claim the benefit of the aforesaid rule as she was studying a course online which was approved by the state government. Paragraph, however, learned counsel for the petitioner prays for short accommodation to enable her to amend the writ petition. How much time?
Monday.
Prays for adjournment, prays for adjournment to enable her to move an application for amendment. List on. As prayed. List on. Monday is what date? 28th August. You give that 1 minute. Give that please for a reference so that exactly we may not be correct. One right, madam. Mr. Rao submitted that. The petitioner may have that the petitioner has resided for 7 consecutive academic years in Hyderabad, ending with the academic year in which she appeared in relevant qualifying examination. However, as she has studied in an educational institution approved by the government, therefore she is not entitled to claim the benefit of this rule, then remaining order remains the same. Yes. NCC quota. Please see what quota.
For the petitioner.
Mr. Rao, ready?
I do not wish to detain my lords any further. Your lordship may take it up tomorrow.
No. What is the, at least you can tell us what is the challenge? What rule?
An amendment to the rule providing for 1% reservation for NCC candidates. Doing away with the reservation altogether is under challenge, my lord, in the writ petition.
Weightage is given instead of you.
Now, grace marks are given instead of percentage of
being given rather than a horizontal reservation.
Only to some categories which were existing earlier. Large number of categories are existing, only 3 are given.
No, but this thing NCC candidates instead of quota are being given weightage.
Not all.
Grace marks were.
Only 7 are given.
Lot of not certificates have been generated, but therefore,
so what NCC, some candidate, how many categories of NCC candidates are there? ABC we know.
ABC is there.
And any other end?
Only B is
any other category, only 3 categories.
Yes, only 3. And also, my lord, those who have participated in Republic Day parade, those who have participated, there are various categories, my lord.
No, so that's why we ask for our benefit.
Yes.
A, B, C category, then 4th is 15th August and Republic Day. Participants in 15th August, Republic Day, and what is 6th category?
And my lord, Sainik camp, those who have participated in Sainik camps, those who have gold medals.
Gold medals.
All of them are done away with, my lord. Only 3 categories are given
So
now.
like 7 categories.
Yes, my lord. And those who have also, my lord,
your preference is that whom has been given weightage?
only B category.
B.
And those
so you are A category.
I'm A category.
A category.
Yes.
So you are not concerned with others.
I'm not concerned.
You only want that A category should get.
That is all my case.
Weightage.
No, my lord, we are saying restore the reservation. Remove the weightage.
So you are in fact a representative capacity for all.
I
know.
I seek only.
Just try to understand. We don't have the right. Yes, so, like if the effect is that if petition is allowed, this thing, so all other candidates will be thankful to you for fighting the battle on their behalf and including them 26 January, 15th August and whatever. Sainik camp, everybody will get 1% reservation.
Yes.
See, Mr. Petitioner is so generous, Mr. Rao, you should emulate him. Not sacrificing his case for other category also. Not saying that only B category. So you are challenging that rule.
Yes, amendment to the rule is challenged. But I'll file.
No. So 1 minute, the amendment to rule is struck down.
Yes, my lord.
Then what happens?
Then what happens is, my lord, I'm entitled under 1% wherever I stand.
No. So 1% is automatically restored, right?
Yes.
That's the position.
Yes.
So it's a this thing. What is the substitution of the provision?
No, my lord, it's a case of deletion. The earlier provision is deleted. They don't even say in so many terms. One of the grounds is ambiguity.
What we are just trying to broadly understand. So supposing if the provision which has been deleted is set aside as ultra virus.
Yes.
Example.
Yes.
What is the effect?
Effect is, my lord, it gets restored status quo ante from the date the
That's what will happen supposing if they you are saying a provision has been deleted by an amendment and we set aside that order after hearing all of you.
The amendment is set aside.
Huh?
The amendment is set aside.
Amendment
The amendment is set aside. Challenge is to the amendment to the rule. If the
amendment
is
by
set
which
aside,
it is some provision has been deleted.
if the amendment is set aside, the rule is restored.
He is saying no. What happens, Mr. Rao? So for what is your version? If the petition is allowed, what happens?
I am instructed to appeal. If it is.
No, we are not arguing. He is not arguing the case, right? We are just trying to understand, so that when they argue, you argue, we understand. So supposing if the petition is allowed, what happens?
We have to go back to GMS 114. Where
Reservation provision providing for reservation is restored, correct?
Yes, my lord.
He is not seeking why we are asking repeatedly, because we cannot issue a direction to the legislature to provide reservation by amending the law. That was the anxiety. To understand that
whether a mandamus
in that context we are.
Yes, my lord, whether a mandamus can be issued to directing the government to provide reservation is a question.
Done.
That's what.
He is agreeing can't be done.
It can't be done.
That's well settled law, will it?
Huh?
Law is settled on that.
Well settled.
Law is settled on that.
At least we are happy that before argument of this case, both of you are on a same page. So far as legal position is concerned.
Common ground. It's a little peculiar case. Why?
Very common ground to begin with. Very good, right?
Yes.
Barely it happens.
Yes.
A little peculiar case here in Malad.
No.
Central government has directed.
We will hear.
Yes.
This he has to argue. So the effect of supposing if that amendment is struck down, there is already a provision which gives him the benefit. So we have to confine ourselves to only whether that provision is what they have power. It's the only thing is arbitrary. What's the possible point? Unequals are sought to be treated as whatever equals.
Article 14 arbitrary.
I like that, sir. Yes.
I will support.
Yes. So, which is the provision? Which is the provision amendment? Just
now,
towards the
Roman 4 method is amended.
Page.
Yes.
Let's see. No, we are not asking you to begin, right? Just provisions. Yes. This only provision we want to see. What is it?
The provision is at page. It begins at 38. It begins at 38. Kindly go to page 42.
38 is Aadhaar card.
42, page 42.
38 is Aadhaar card.
Page 42, Miller. My lords are taking item 54, Miller.
It's 53.
54. I'm sorry, Miller. 53 council. Says
The council has gone home.
He said,
Relying on you. See how tremendous confidence people have in your skills.
He said so and went away.
We are dealing with them, Millards. That's the reason why. Let them argue first, Millards. After that, we will be arguing, Millards.
No, nothing arguing. After senior council argues, what is there?
Very well.
You will adopt, but you must know what has been argued to adopt. One thing, just like a council like you, the senior council, the council finished the argument and he said, I adopt. And he had just walked in. That argument was going for 1.5 hours. And the council like you just walked in and sat down 2 minutes and said, I adopt. So the bench headed by the Chief Justice asked what they have argued. You must know before adoption. So don't be in that position, right? Be there when he argues.
Page 42, Millard.
42.
Roman 4. C is deleted.
National jobs. You will apprise us about the scope of judicial review in such a case, doing away with horizontal reservation.
Yes.
That is a point involved in this one.
Everything we say, you say point involved.
Yes.
You tell us what is the point involved first.
Well, I say.
Huh?
When my turn comes, by that time means we are running quick.
No, you are saying whatever we say, you are saying this is the point involved. So therefore we ask you, what is the point involved?
Point involved is whether mandamus can be issued is the enabling provision. Under Article
He is not
16.4
seeking
or
a-
15.4 is an enabling provision.
Arey, mister, he is not seeking a mandamus. He clarified, right? You started off a common this thing around.
So Ashekar, please look at page 17 of GO 75
Yes.
under the note. First point of the note.
18674, right? Your WP.
Nice that.
Please see 17, page 17.
My lords are referring to the latest 75 or the earlier 75.
That is the 8/9/2015.
Yes, that is the one which provided for reservation.
Now the subsequent thing, they are
Now,
only
my lord,
giving
the latest one which is challenged is at page 19.
19, yes. In this, they are giving 7 for.
What is
not
that?
that everybody is being treated the same. Even here, they are giving weightage based on the your.
Page 21, my lord, is the amendment.
NCC, if you have participated in RD, Republic Day Parade RD, then it is 7%. Then if it is Sainik Camp, it is 5%. Other NCC B certificate is 3%.
A is left out. A is left out.
Okay, we continue tomorrow.
Very well.
Tomorrow. No other cases.
Subject.
Lunch motion is closed.
Your lordships, they are also with respect to the medical admissions, your lordships. However,
It's lunch motion.
lunch motion.
List along with Madam lunch motion, list along with
the issue,
WP
your lordship,
number 81.
your lordships, these
80.
your lordships in these matters.
1 minute. Item number
83, your lordships.
83. List along with WP number 18047/23.
Or maybe your lordships, the matters may be taken up as fresh matters tomorrow because your lordships have sought for a separate interim order because your lordships with respect to the second council. In fact, your lordships, the 83 batch that is dealt with in relation to the first council. My interim application is separate, your lordships. In fact,
You said that it is linked and all that.
on question of law, it is linked, your lordships. However, I've sought for a separate interim order. The issue.
But
The
interim
interim
relief is interim relief.
Interim relief is separate, your lordship.
No, see, why? If we supposing grant interim relief, you can go to Delhi. If you doesn't grant interim relief, we can go to Delhi. In a case where we had not said anything about interim relief, the council went to Delhi and you know what happened in that case. Came back. So he wants to go to Delhi. Weather appears to be good right in
I'm
Delhi.
just being hopeful that I might get the interim order considering I'm only seeking a direction and not a suspension.
Since you have appeared before us, I hope that you knew the bench, right?
Absolutely.
At 2 o'clock, what can we?
Absolutely. Tomorrow, your lord. I'm only requesting that they may be taken as fresh matters tomorrow.
Lunch motions, item 1 and 2. List tomorrow. 9?
9 matters, your lord.
You said 1. You said 2 cases and then got listed 9.
I gave the slip for 9 matters. Your lord.
Is there an interim order in other cases? 81 matters, 83.
83, your lordships, there is an interim order where the
subject to hearing, list tomorrow, madam, 9.
As fresh matters.
Subject to lordship's pleasure, my lord. Lordship's pleasure.
has it been admitted? Then how it will not be treated as fresh? Huh? It will be it will come up for admission only.
Subject to lordship's pleasure, my lord, I may permitted to make a mention in respect of one matter, item number 109 to 113, where the transfer of the teachers.
It's continuing, Mr. List. We are not adjourning. What do you think? This is like these students have left us today. So now after we are looking for other still student, he is not leaving us. So you talk to him, teacher recruitment batch, whether he wants to argue, whether he will permit.
Because entire state administration, just I'm
No.
difficulties of the state I'm bringing to your lordship's notice, my lord.
No, Mr. You should mention at 10:30, 2:30, whatever.
I
And it's not being adjourned. It will come up
I was
tomorrow.
under the impression that your lordship would reach today, my lord. Tomorrow at 2:30, my lord, your lordship may kindly say. The entire department is looking at your lordship, my lord. 860,000 teachers are looking at
1
your
minute.
lordship. I'm sorry, that's all.
attached to.
You haven't told except for entire state and looking, they should look at father of the nation, how he used to live. What this is such a beautiful portrait. They should look at this. And it's any case live stream. We will ask them to focus on that beautiful this thing. At 5 o'clock, Mr. You expect us to take up the case.
Tomorrow
Go
at
ahead.
10:30. Tomorrow at 2:30, this matter may be taken. In
What is the
otherwise, I would
urgency?
not have trouble, your lordship.
What is the urgency?
Urgency, my lord, the transfers of the teachers had been come to a grinding halt from 14th February 2020.
This again, Mr. Somebody had made a mention in the morning. Are you aware?
Yes, my lord. They are also trying.
No.
Special government leader,
Santosh.
Mr.
Sit down,
Santosh
madam.
made mention.
Santosh.
Special government leader attached to the office of Advocate General, Mr. Santosh had made a mention. We asked him about the facts. Then
Other.
Santosh. Mr. Santosh had appeared in this matter, saying that it is teachers transfer and all. So we said we have a priority for the students. That is why we will not take it up. That is what we indicated to him.
It's continuing in the list. The moment it is over, Mr. You be brief, right? You must give way to teachers transfer. It's a big industry, right?
Yes, my lord.
We can appreciate their anxiety.
My friend also has to be brief.
Even if you get admission, there will not be teachers.
There will be. So how much time will you take tomorrow?
I won't take more than 30 minutes.
Conclude in 20 minutes.
Very well. I'll
Yes.
do my best.
We appreciate, like,
Yes,
we
ma'am.
understand what is policy point. And Mr. Rao, as usual, he will be very brief. Mr. Rao, correct? You have filed counter, etc., right? It's being heard. But why should we hear you finally?
To your lordship, there is an interim order. They have not complied with it. To accept my application, they have not complied with it.
Because Mr. Rao, you will appreciate that every case we cannot go on hearing finally. Right? Will you appreciate?
In fact, this case is posted to 29th. my lord. He made a mention. Yes.
So have you complied or have you filed vacation?
Lordship, I will file an application to vacate and Lord, the NCC admission to NCC special categories has not yet taken up. Not yet taken up. The question of consideration doesn't arise. May file a contempt case against us even before considering. The occasion has not arisen for consideration. We file a contempt case.
Now we will modify that order. So, Mr. As and when it is notified, as and when it is round of counseling is notified for NCC candidate, then you can make a prayer But there are some other cases, right?
It is he who is pressing for hearing. I am not, my lord.
No. But he has filed an application seeking modification of stay, and why he is pressing is that you are threatening him with contempt, where he will go.
But your lordship may
That's what you did not hear Mr. Rao saying that. Yeah, 1 minute. You did not hear Mr. Rao saying that there is no question of compliance because that schedule of counseling for NCC candidate has not been notified. How they will consider?
When the time comes, let him know. When the time comes, let him know. No, I will
So
not
therefore,
press
contempt. It is our duty to protect him from contempt.
Your lordship may record, I will not press the contempt. Let him consider when the time comes. That's all I am saying. Yeah, let him record his undertaking also.
NCC.
Item 54, madam.
Ray, you should have said, Mr. Rao, in the beginning that this is what at least be clarified. We would have done it, not repeated.
Yes,
tomorrow.
Yes.
We have to permit the industry to flourish, right? Additional AG. Transfer industry should flourish, right? Huh? See, 10/8/23. See, after 3 weeks. 3 weeks. Because not 3 weeks is not over.
Status from the report, seeking that. And in the meantime.
Where is the interim order, Mr.?
Page 9, my lord.
Of vacate petition? Page 9. Not there.
That would be 18674.
18674. We have got 18674.
That's which is the interim order.
Counter.
No, date of order. Interim order when?
Date of order is 14 July 2023, madam. It is
That is the date, that's the last date of application.
Yes.
It is at page 7.
1 minute.
Yes.
So, admission to first year course by tweaking NCC A category candidate. Your application. 1 minute. Their application has been entertained.
But consideration to A category does not arise in view of amendment to the.
That is the issue, but despite that, the interim order has been passed, right? All right. Mark the presence. In this writ petition, we will modify the interim order to save you from clutches of contempt.
Your lordship may also kindly consider directing them to consider whenever the situation arises.
No, you let them file counter everything. We will hear it.
Sir,
we will hear it. Not tomorrow.
Whenever
we will hear it whenever you please mention the matter that or this thing, the schedule of admission is going to be notified or notified, we will hear.
Your lordship may kindly record his submission that they are not notifying this category. That's all what I wanted to say.
Not notified as on
He
today.
said so right now. Kindly record his submission.
Yes, definitely. Yes. In this writ petition, comma. Mr. You must sometime, please take some time. You all are very busy counsels, but we have go through the prayer clauses in the petitions and find it very like all of you have not read. It gives an impression that none of you have read the law of writs. You are saying mandamus seeking insertion of clause so and so arbitrary, illegal.
Yes, my lord. Very well.
Mandamus can't be there. We have to rephrase so as to this prayer clause should be, otherwise we will be, anybody can say, see what High Court is writing. It doesn't know scope of writ petition, a writ of mandamus. What, Mr.? At least read it. I mean, we know that this all, it must be fed in the computer and thereafter second line you start typing or somebody this thing starts typing.
Very well, my lord.
Please go through it before signing.
I will do that.
In this writ petition, comma, the petitioner has assailed the validity of amendment made by insertion of clause 3, Roman small 3 within bracket A, within bracket small a of Telangana, A in rule 4, rule 4 of Telangana Medical and Dental Colleges admission within bracket admission in MBBS and BDS courses bracket close rules 2017 17 full stop, by which the provision prescribing for reservation of to horizontal reservation of seats to MBBS course to the extent of 1% has been deleted. Paragraph. A bench of this court by an order dated 14/7/2023 had directed the university to entertain the application of the petitioner for admission to first year MBBS course by treating the petitioner as NCC A category candidate. However, it was also made clear that the admission of the petitioner will be subject to further orders. Paragraph. Learned counsel for the standing counsel for the university, while inviting the attention of this court to averments contained in the vacate stay petition, has submitted that in compliance of order dated 14/7/2023, the university has treated the petitioner as NCC A category candidate. Since it is further submitted that a separate counseling is required to be held for admission to in respect of NCC seat, since the aforesaid schedule of since the date of counseling has not been notified till today, therefore it is not possible for the petitioner for the university to admit the petitioner under petitioner who belongs to NCC category candidate at this point of time in the face of the rule which is impugned in this petition. It is further submitted that the interim order be modified as the suitably modified, as the petitioner has filed a contempt petition against the officers of the respondent university. Paragraph. What do you submit?
But I just wanted to say that let them
The
consider
learned
whenever
counsel for petitioner has opposed the prayer made on behalf of learned counsel for the university. Paragraph. We have considered the submission made by learned counsel for the parties. The university has already entertained the application for petitioner, entertained the petitioner for admission to MBBS course by treating the petitioner as NCC A category candidate in compliance of the order passed by a bench of this court. However, the question of admitting the petitioner to the MBBS course at this point of time does not arise, as the counseling has not been notified. Counseling for admission to against MBBS seats has not been notified. Therefore, the interim order dated 14/7/2013, insofar as it directs admission of the petitioner to this court, is modified, and it is submitted that as and when submitted that the petitioner shall be at liberty to approach this court with regard to his grievance for provisional admission, and as and when schedule as when and date for counseling in respect of NCC seat is modified. A is notified. Accordingly, IA number so and so is disposed of. Correct.
whenever
You
my lord,
file
they are
counter.
considering case. Counter is filed. my lord.
You have filed.
Yes, my lord. Counter is filed.
The petition is admitted for hearing.
My lords may kindly consider directing them to, my lord, whenever they are undertaking, let them consider the case of
54, 55 same order, 56 same order.
53, my lord.
56, not.
1 minute.
I made an IA for amendment of prayer.
56 for amendment.
So the same order which has been passed in his case.
56, not I find I
Amendment. Yes, Mr. Prabhakar. Allowed. 56 taking in what?
amendment of the main prayer.
No. What is the prayer?
I had earlier not challenged.
Heard on IA number 2 of 2023, Learned Counsel 56, madam. Learned Counsel for the petitioner submits that inadvertently he had not assailed the validity of the aforesaid rule. By the proposed amendment, he wants to challenge the impugned rule. So and so, whatever rule previous case we have written. The aforesaid prayer is fairly not opposed by Learned Counsel for University. taking into account the averments made in the petition, as well as for the reasons assigned so and so, the IA is allowed. Let amendment, let office is direct. He will, he
File a fresh amended.
fresh amended petitioner shall incorporate the amendment and file a fresh petition, amended petition.
NCC has to file counter, my lord. NCC has not yet filed its counter, counter not to.
With how much time?
It's not done.
2 weeks, huh? Then previous case also, counsel, Mr. Praveen Kumar.
None of the cases.
DSGI. Praise for and is granted 2 weeks time to enable him to file count. Fine. So if this takes care of this thing. Up to, so no other case, madam? Only that bunch comes. Why you should be heard, Mr. There is an interim order, right?
In the batch from 83 to 86, your lordships, there is an interim order.
Ah.
These are fresh matters, your lordships.
So let's see what we are sitting here, Mr. Rao.
Kindly see, Lord,
No. So you have got the notice or you want to argue it tomorrow?
I want to argue tomorrow.
Tomorrow, fine.
There are also these things from 8 to 17.
8 to 17 are similar matters.
Identical to the lunch motions.
There are similar matters.
7 to 17.
7 to 18, your lordship, they are also for the.
1 minute.
Lord, 83.
Issue in 7 to 17, there is an interim order.
No, your lordship.
No,
They are also fresh matters.
All fresh matters which have come.
There is an interim order. Those they were direct plus 7 to 17.
So it was called no 7 to 17.
Yes, your
You
lordship.
said.
I was under the impression that 81 would reach your lordship. My sincere apologies. They may also be taken up tomorrow, your lordships. I am only arguing for IA.
IA, you should argue only for IA.
Obviously.
Because it's,
Absolutely.
there is always a limitation. We are also human beings, right? Every case there is an interim order. We cannot keep on hearing every day till 5:15.
I will not take more than 5 minutes.
5 minutes to argue interim relief only. You get interim relief or go to Delhi. These are the two possible scenarios. Or Mr. Rao goes. He doesn't want to go to Delhi.
Neither do I want.
Huh?
Neither do I
You
want.
also don't want. Okay, good.
I'm being hopeful here.
No, but Delhi is a good place, right? You should go. Okay, we'll see tomorrow.
Obliged.